may be permitted to move an unlisted with an eviction matter, madam.
You want to do it unlisted? Can't
Yes.
wait for tomorrow.
No, today is the last date, madam. Actually, my lord, what had happened, the matter went up to Supreme Court. Supreme Court has given certain guidelines. In terms of that, in fact, the other day, another petition was listed before court number 17. It has been disposed of in terms of the Supreme Court. Supreme Court has said, my lord, that the personal hearing must be given. Even if the order goes against them, then reasonable opportunity should be given so that we can approach other forum. So in terms of that, I'll be praying for a direction.
All right.
Deeply.
May I please, your lordship? I beg to mention for listing a case of writ petition civil 125(8)
Listing for what?
admission.
Putting an application before the registry. Judges don't list. Mention is meant for urgent orders. So you make a request to the registry. If they don't list, then you come back.
Sometimes I have submitted the application.
Show me the copy.
Copy not very.
Then you have to follow the process.
Today may be allowed.
All right.
Lordship, I would like to my lord, mention item number 17, my lord. My lord, I would like to withdraw this matter with a liberty to.
No, I am rejecting your prayer for listing. You first make an application, then come back. Yes.
May I please, Lordship. Item number 17, Lordship. I pray for my lord withdrawal of this writ petition with a prayer to file a fresh one, my lord. The prayer part is some defects are there, my lord. Item number 17.
Mr. S. Shamarial, counsel for the petitioner, submits that there is some defect in the prayer portion of the writ petition, and therefore the petitioner be granted liberty to withdraw the writ petition with liberty to file a fresh. If the prayer is not opposed, same stands allowed. This writ petition stands disposed of on withdrawal with liberty as paid for. Yes.
Deeply.
May I praise your lordship? Should I pray for listing of 3 matters as unlisted matters to the lordship? Lordship, eviction matters, lordship, we were served with a notice on Saturday, and we are to be evicted by 4 PM today itself, lordship. Therefore, lordship, there is urgency. Oblige, lordship.
May I speak to you, Lordship? I beg to mention in item number 37, but I have filed an interlocutory application on 17 for impleadment matter. In the meantime, the matter has been listed for today. At item number 37, that may be called for.
Interlocutory application.
Yes.
It cannot be called like this. It has to be listed. Either I pass an order to list it together with IA.
Yes, yes,
Item number
37.
37. You write Mr. S. Islam.
R. Islam,
R. Islam, learned counsel for the petitioner, submit that.
not petitioner, matter.
Sorry. You have informed the petitioner's counsel.
No, matter, not yet. I have.
Let the matter be called.
Okay,
up.
yes,
It comes.
that's better. Much of.
May I please, your lordship? Lordship, I'd like to mention for listing of an item for Wednesday, lordship. We have already approached before registry, lordship, but matter is not listed, lordship.
You give her the number. You find out why it has not been listed.
Lordship.
May I please, Lordship, Lordship, I beg to mention item 35, Lordship. Lordship, kindly adjourn the matter for the today, Lordship. Lordship, on Thursday, respondent file affidavit in opposition. I need 1 week time for filing. Filing.
You are for the petitioner.
Yes, Lordship.
Your name?
A. Islam.
Mr. A. Islam, learned counsel for the petitioner, submits that he has received a copy of the counter affidavit filed by the respondents and therefore be granted 2 weeks time to seek instruction. Prayer allowed. Let the matter be listed accordingly. Yes.
Okay. May I please, your lordship? Lordship, may I pray for listing of a eviction matter day after tomorrow, lordship?
Yes.
May I please, your lordship? I beg to mention item number 46. This matter may be taken after 1 week because the learned engaged counsel, Mr. M. Shik, is out of station. 46.
Urging that the arguing counsel for the petitioner is out of station. A prayer has been made for adjournment in this case. First up, in view of the ground cited at the bar, this matter stands adjourned for 2 weeks. Yes.
Hello, guys.
May I please, your lordship? I would beg to mention item number 33. Lordship may not take up the
This
matter.
is before any other bench without me.
May it please, your lordship? And may I kindly be allowed listing of 2 matters, similar matters concerning land acquisition on the day after tomorrow for motion, my lord. Much of that.
May I please, your lordship? I'm mentioning for listing matter, motion matter, madam, on 23rd matter.
What is the matter?
No matter relating to settlement of Kamakya Deputy Land matter, some dispute arises matter. Our station advocate is engaged in this case matter on 23rd matter. Deeply obliged.
May I please, your lordship? Lordship, with the consent of the opposite party, I beg to mention item number 27, 28, and 29 for adjournment.
My lord, all these three are analogous matters. As directed by this honorable court, my lord, we have filed two affidavits, one by the acquiring authority, one by the requiring authority, my lord. It's a land acquisition matter, my lord.
And
That is why matter was fixed today, my lord.
Actually, he is for the petitioner.
He is for.
Yes,
Seeking adjournment, any
Yes.
objection?
for 3
Uh,
weeks.
eh?
For 3 weeks, we need to.
Is there any interim order?
No, I have no objection to that. As directed by this honorable court, we file it.
All right, Mr. Your name, please?
R. Borua.
Mr. R. Bora, learned counsel appearing for the writ petitioners in this batch of petitions has prayed for adjournment in this matter with the request to post the cases again after 3 weeks. Mr. B. Goswami, learned additional AG Assam appearing for the
For all the
water
respondents.
for all the respondents submits that in terms of the order of this court, 2 affidavits have been filed by the concerned authorities. But he does not have any objection if the prayer for adjournment is allowed. In view of the above, registry to take the affidavits with the record of this case and list the matters again after 4 weeks.
Obliged, Lord.
May I please, Lordship, with the consent of other side, I beg to mention item number 32, Lordship. So the matter will be taken after a week.
There is nothing called 1 week. Adjournment will be 2 weeks. You are for whom?
For the respondent, Lordship.
You have informed the petitioner.
Lordship.
You have informed. With the consent of learned counsel for the petitioner, Mr.
A. Dhanuka.
A. Dhanuka, learned counsel appearing for the bank 6 posting of this matter again after 2 weeks. Since the prayer is not opposed, same stance allowed. Let the matter be listed accordingly. Yes.
May please, Your Lordship. My lord, I beg to mention item number 37, my lord. In this matter, my lord, I would like to file a reply, my lord.
That is what somebody else has mentioned.
37, my lord.
You are for whom?
I am for petitioners, my lord.
So respondent has also mentioned the matter.
The private respondent is not there, my lord, in this case.
What do you want?
I want sometimes 3 weeks, my lord. I have filed reply.
Mr. AFNU Molla, learned counsel for the petitioner submits that he has received a copy of the counter affidavit filed by
Respondent number 5.
respondent number 5 and therefore be granted. How much time?
3 weeks.
3 weeks time to seek instruction and file rejoinder. If so advised. Full stop. Mr.
Obliged.
For the respondent, Learned SC PNRD Assam is present on behalf of the official respondent. Prayer allowed, list the matter accordingly.
May I please, Your Lordship. My lord, I am mentioning in the matter, my lord, which has been fixed on 23rd, my lord. And in fact, my lord, it was earlier in oral communication, we have heard that matter is fixed on 16, but not on 16, it is 23rd. I have problem on that day, my lord. My lord, I'm praying that matter will be taken up tomorrow or 24th, my lord.
When it comes up on 23rd, you ask your
My
junior
lord,
to
I will be on
somebody to
outside
take a-
of Guwahati, my lord.
We can't allow a mention like this. This is not permissible. When the matter is called up, your prayer will be
My-
accommodated.
My
You ask somebody to remind,
lord.
it will be done.
Yes. May I please, Your Lordship. My lord, item number 38, my lord.
Hmm.
This matter may be adjourned for a week, my lord, only. I am for the petitioner, my lord.
On the prayer of Mr. A.H.M.R. Chaudhary, learned counsel for the petitioner, made with the consent of the other side, this matter stands adjourned for 4 weeks. List accordingly. Yes.
May I please, Your Lordship? I beg to mention for listing on writ petition relating to settlement of market.
Hmm.
Can it be on day after tomorrow?
Listing for what?
Listing for motion.
What is the urgency?
It's a settlement given to the other party on last month, Lordship.
Yes. So it will come. What is the urgency?
And we have filed on last week. So
Let us see if it is not listed, then you make a mention on Wednesday. If it is not listed on Wednesday, you make a mention, we'll have it on Friday. Yes.
Mayor, please, item number 11 and 12.
Sorry?
Item number 11 and 12.
Yes, what do you want?
May I have liberty to withdraw my case?
11 and 12.
Yeah, and file liberty to file a fresh.
Why you want to withdraw?
I have some defect in my
Huh?
plane. I have some defect in my plane.
You
I've-
have some defect.
Yeah, I have some defect.
What defect?
I didn't, I find some mistakes that in my plan, I have forget to fill up this pattern number. That was mentioned in the synopsis, Lord, my lordship.
What is your name?
My name is K. Kopham.
K?
Kopham. KOPHAM.
But you're not an advocate on record here.
Huh?
I was in my in the last part, last. Keshan Kofam Kanso, my short is K Kofam, my lord.
Take down Mr. 11, 12, same order, Mr.
K
K-
Kofam.
Kofam,
Yeah, man.
KOFOM,
KOPHAM.
KOPHM,
PHAM.
PHAM. Learned Counsel has appeared for the writ petitioner and submits that there are some defects in constitution of the writ petition, and therefore liberty be granted and therefore leave be granted by this court to withdraw the same with liberty to file afresh after rectifying the defect. The prayer made by the petitioner's counsel is not opposed by the respondent. As such, this writ petition stands disposed of on withdrawal with liberty as prayed for. Same order in 11 and 12 both.
Deeply obliged.
Well, that's for the last order, instructions were sought for from the Deputy Commissioner's office.
By the
Because,
some portion of land is related to wildlife sanctuary because sensitive. So it will depend.
examine.
Yes.
In fact, my lord, I'm told that today some letter will be issued to us also for some clarification, my lord. We have been called today at 10:30 to the office. Some clarification from the forest department, my lord, probably.
So it falls within the eco-sensitive zone.
Yes.
My lord, that is what I have just seen. Some letter, my lord, in this regard, my lord, will be issued to us today, my lord. We have been called at 10:30, my lord. We'll
All
clarify.
right,
that.
you take down heard Mr. B. Pathak, learned counsel for the writ petitioner, also heard Ms. M. Burman, learned government advocate Assam, who has produced a copy of the written instruction dated 17/8/2023, issued in terms of the order dated 9/8/2023, passed by this court, full stop. A perusal of the written instruction goes to show that the land connected with this writ petition, although is located outside the boundary of the Amsang Wildlife Sanctuary, the same falls within the eco-sensitive zone, full stop. The written instruction further mentions that the proposal is being examined in consultation with the forest department. Full stop. Mr. Pathak submits that his client has been given to understand that some more clarifications would be necessary in this matter, and therefore the writ petition will be posted for motion again after 2 weeks. In view of the prayer made by the petitioner's counsel, let this writ petition be listed for motion again after 2 weeks. A copy of the written instruction dated 17/8/2023 be retained in the record of this case.
Lordship, it is a disqualification of membership for free trial, Lordship. Lordship, ask them to submit instruction.
So what has happened? The no confidence special meeting was held,
Lordship.
and then what is the outcome of that?
Lordship, no resolution has been taken to by my information, and all the files and resolution has been sent to Deputy Commissioner. But 6 members were present only.
So then we'll close it by asking the Deputy Commissioner to take a decision. Already he is inquiring into the matter.
Lordship.
Let him take a decision, appropriate decision as per law. We'll close it accordingly.
Lordship, with your observation, Lordship.
Yes. Heard Mr. P.P. Datta, learned PP, right? PP Datta, why have you written PB? It's not PB, PP Datta, learned counsel appearing for the writ petitioner. Also heard Miss M. Burman, learned government advocate Assam, appearing for the respondent numbers. Respondent number,
3, 4, and 3 and 4.
respondent numbers 3,
3 and 4.
3 and 4. Mr. N.K. Devnath, learned SC PNRD Assam, is present on behalf of the respondent numbers
1, 5, and 6.
1, 5, and 6. Full stop. In terms of the, yeah, you're right. The grievance of the petitioner is that although the respondent number 7 had incurred disqualification on the ground of contravention of section 111 bracket 2 bracket close of the Assam Panchayat Act 1994 for having more than 2 children, and therefore was ineligible to participate in the specially convened meeting of the Gaon Panchayat to be held on 16/8/2023 for discussing the no confidence motion brought against the petitioner. No action has been taken by the district administration, although she had lodged a complaint to that effect. Full stop. In terms of the order dated 14/8/2023 passed by this court, Ms. Burman, learned government advocate Assam, has obtained written instruction issued by the respondent number 3. I have perused the same. It appears that the matter is under examination by the respondent number 3 and is awaiting appropriate decision in the matter. Full stop. Mr. Datta has also appraised this court that in the meeting of the Gaon Panchayat held on 16/8/2023, only 6 members were present, but no resolution would be adopted in the same meeting. Full stop. He further submits that the records have been transmitted to the office of the respondent number 3 for appropriate decision in the matter. Full stop. Considering the fact that the respondent number 3 has taken cognizance of the complaint lodged by the petitioner, and having regard to the fact that the allegation made against the respondent number 7 would require factual verification so as to take further action as per law, this court is of the opinion that instead of keeping the writ petition pending before this court, proper course of action would be to direct the respondent number 3 to verify the allegation made by the petitioner and thereafter take appropriate decision in the matter as may be permissible under the law. Full stop. The learned counsel for both the parties have also agreed to such a recourse. In view of the above, without expressing any opinion on the merit of the case projected by the writ petitioner, this matter stands disposed of at the stage of motion hearing with a direction upon the respondent number 3 to examine the complaint made by the petitioner in the light of section 111 bracket subsection 2 bracket close of the Assam Panchayat Act and thereafter take appropriate action in the matter as may be permissible under the law. Full stop. In doing so, the respondent number 3 shall give an opportunity of being heard to the petitioner as well as the respondent number 7. Full stop. Until such time. No, that's all. Depending on the outcome of the process, the respondent number 3 may also take a decision on the validity of the meeting held on specially convened meeting of the Gaon Panchayat held on 16/8/2023. With the above observation, this writ petition stands closed.
The only liberty may be granted to the petitioner if he may approach again if.
Is there a bar? Yes, what is the
Good
matter?
morning, Maya. That's it.
What is the
May I
matter?
please? That's it.
Petitioners have not received compensation.
Uh,
No
Yes, my lord.
compensation.
Yes, my lord.
Lordship, they have received, part compensation has been received.
Remaining part of.
So perhaps they're
compensation.
not satisfied with the
Exactly.
amount of compensation given to them. Inadequate compensation is perhaps their grievance.
What was the compensation determined?
Lordship, I have to seek instructions, but then Lordships may kindly go to page number 23.
Yes.
So Lordship, the compensation has been determined for the area that the RAU is passing through,
Hmm,
the right of usage.
hmm.
The writ petition is averring that the land has been acquired, but Lordship, the land has not been acquired, only the right of usage has been acquired. And that too only through the area through which the pipeline is slated to pass. So compensation has been given to them for that through the area through which the land is passing. In case they're not satisfied with the amount of compensation, they can approach the district judge under section 10(2) of the act.
Let us see where is, which act? 10(2) of-
PNP Act, Lordship.
10(2) of?
10(2) of PNP Act.
Actually, Lordship, my total area was 3,250 square meter.
Hmm.
Under plot number, tag number 82 and plotta number 312. 312, but compensation has already got both of us, my lord. 1,728 square meter. Among 3,250 square meter, my lord.
So
But-
if you are not happy with the compensation, you have to go to the district judge. That's, writ court cannot decide this.
There are matters of evidence, Lordship, how much land has been acquired, whether they claim the grievances.
These are
No, my
matters of factual inquiry.
No, my lord, we have already.
You are not
filed-
willing, you are not
petition.
willing to go to district judge's court. You will go after 4 years. You want to go today or after 4 years, you take a decision.
No,
I'll issue notice, admit it, it will lie pending, and someday when there is a full length hearing, when they show this section 10(2), then you will say, I'll leave it to your lordship. Then the matter goes, but just for your stand, which is not in accordance with law, the clients suffer. This is
What-
what we are seeing.
we have
You are
already-
insisting on this matter to be admitted. The writ court will never decide this matter. We'll always send it to the court. I can send it today or I can send it after 4 years. But you will be the loser. Your client will be the loser. You decide what you want to do.
We have already,
All right, all right.
informed
I'll admit
the
it, let it
concerned
remain
authority, my lord.
pending. Yes,
Lordship, GAIL India has not been made a party. I am appearing on behalf of S. Mitra SC GAIL. GAIL India has not been made a party. The competent authority has been made a party, but competent
my
authority
lord.
is discharging function as a
Already-
quasi-judicial body.
That's right. You file your affidavit.
Already. GAIL
Lordship will
India,
file
my
an
lord.
pleading application.
GAIL India had give to our notice from GAIL India, and GAIL India is the concerned authority,
You are appearing for
concerned
whom in this
authority.
case?
On behalf of S.
not
Mitra SC
competent
GAIL.
authority.
But you are, madam, you are making a mistake. You are just not doing things right for your client.
Not my lord.
This matter will never be adjudicated by the High Court. Never. You are just delaying relief to your client. That's all.
I already.
You do one thing.
We
You-
have.
You talk to your colleague outside and come back after 15 minutes. Huh?
Okay, then.
You expect the High Court to figure out how much land has been acquired, how much compensation you are required to pay, and then pass a writ of mandamus. Is that what you are expecting?
Yes, my lord.
We will never do that because that is not permissible.
So then appropriate order may be passed.
Huh? So
So-
you tell us what appropriate order.
So.
He is saying that there is a provision under section 10(2).
Yes.
You can approach the district judge saying that we are not happy with the compensation because according to us, the land affected is this much. It is more than what they are projecting. District judge will call for evidence, then give a finding, either accept your argument or reject it. If it is accepted, then you will be paid compensation. What have you got to do in the High Court here? What has writ court got to do with this? Huh?
Okay, then we will approach the district judge, my lord.
Huh? No, you discuss and come back. Have you seen the law? Do you have a copy of the act?
Already.
Have you
one time.
seen the copy of the petroleum and minerals pipeline acquisition of right of User in Land Act 1962. Have you seen it?
Uh.
Are you aware that there is a law like this?
Yes, my lord.
Well,
Already we
you
have,
have to answer the question of the court. Don't divert it.
yes, my lord.
Are you aware that there is an act like this? You are aware? Yes or no?
Yes,
Then read out what is written in section 10. What is written in section 10?
Section 10.
10(2).
Mhm. Yes.
Please read.
Please, may I update to chapter another date?
You take this copy, read section 10(2),
Yes.
and we'll take up the matter after half an hour. After half an hour, you come.
Actually,
Yes, after half an hour, call up. Yes, after half an hour. Next
Okay,
matter,
fine.
please.
This petition is regard to the non-payment of contractual bills, Lordship.
This matter appears to be one pertaining to civil bench 4, registered to verify and list the matter accordingly. Yes.
May I please your lordship? Lordship, this is petition, I have challenged the termination order, my lordship.
Termination of?
Termination for, I am accredited engineer, my lordship. So I have been terminated.
Civil bench 3 matter, we will go to that.
Yes.
It appears that this matter pertains to civil bench 3, but has been wrongly listed before this court today. Registered to verify and list the matter.
Quickly apply.
May I please? My lord, limited prayer before your lordship. Lordship kindly see, my lord, at page 22. The respondent number 7 and 8, my lord, are not the biological son and daughter of the, my lord, petitioner's fathers, though their name has been, my lord, recorded in the particular plot of land. So we have filed an application before the, my lord, deputy commissioner for taking necessary action, but nothing has been done, my lord, so far.
What action under which provision of law?
My lord, rule 116 of the Assam Land and Revenue
Let us see
Regulation.
what is that. Rule 116. You have to go to civil court here, Mr. Mandal. Why are you unnecessarily wasting your client's time?
But there is a provision, my lord, rule 116, my lord. The deputy commissioner is the, my lord, jurisdictional authority.
116.
116, my lord.
It is about proclamation of partition.
Under rule, my lord, this is, my lord, I think.
Achha, this is regulation. Huh? You please read out what is the rule.
Yes, my lord. Let it be, my lord, after some time, my lord, I am having to.
Yes.
Please, your lordship. I am entitled Swatantrata Sainik Saman Pension with effect from
Family pension. Is it pension is a civil bench 5 matter?
4.
Huh? 4. 3 matter. It's a civil bench 3 matter. We'll post the matter before the heard Mr. S. Burman, learned counsel for the petitioner. This matter pertains to payment of pension, family pension. But it has been listed before the civil bench 5. This court has noticed that the registry is incessantly listing cases pertaining to civil bench 3 and 4 before civil bench 5, although jurisdictions have been clearly earmarked by the notification dated. What is the notification dated? 27th of July 2023. The joint register judicial is therefore directed to take effective remedial measures so as to ensure that matters are not unnecessarily listed before the inappropriate bench. First up, in view of the urgency expressed by the petitioners counsel, let this matter be listed again before the appropriate bench on 23rd Wednesday. Wednesday it will come up. Obliged, Lordship.
This matter will be adjourned for the day, like some instruction, on Wednesday, madam.
I'm appealing for the caveat orders.
What is the matter about?
It's matter about appointment of a Kaji, madam. In a local jurisdiction, there should be only one Kaji, madam. What I have been informed, my lord, he said, my lord, this person has been serving in a school, my lord. So that information I have.
Appointment, is it a matter of civil bench 5? Acha, you write, Mr. N.J. Datta, counsel for the petitioner seeks adjournment in this matter with a request to post the case again day after tomorrow. Mr. J. Henry, Standing Counsel, Revenue Department, Assam. Ms. G. Hazarika, C. Revenue, Mr. J. Henry, Government Advocate, Assam, and Mr.
M.I. Hussain.
M.I. Hussain, Learned Counsel are present on behalf of the respective counsel. Since it is a matter pertaining to appointment of a Kaji, register to verify and list this matter before the appropriate bench.
I'm okay.
May I please, Your Lordship? It is regarding the impugn notice, Your Lordship, issued by the range officer first. Your Lordship, at page 103. In fact, he has no jurisdiction, Your Lordship. The impugn order was to vacate the land falling on the right of way of the transmission line. Already there was that has been cut down. The land is already vacated, Your Lordship, and for that I have filed a compensation case, which is pending, Your Lordship. And in that case, the National Highway Authority had also admitted that we have deposited for the land and for the Girard, the fund is lying with the Deputy Commissioner, Your Lordship. In fact, if this order is allowed, Your Lordship, that will give us the affect my compensation case, Your Lordship. This land is not a forest land, it is an unsurveyed land.
Lordship, for that, I have to take the instruction out the records, Your Lordship, whether this falls within the forest land or not, Your Lordship.
Already there you admitted I have annexed the
I have to call
affidavit
for
in
the records, Your
opposition.
Lordship. I have to call for the records, Your Lordship. And
Record are already here. I have received compensation. DC has paid compensation.
Listen, wait,
Yes,
don't be agitated. Where is the order showing that compensation has been paid?
Your Lordship, may kindly see Annex 6, page 62. Page 62. Type copy and also the photocopy.
Yes. Page 62 is Axis Bank.
Yes,
Where
we have
is
been paid compensation there, Your Lordship. And Your Lordship may kindly turn to page 66, Your Lordship.
No, there must be some order for payment of compensation.
Already paid, LA case is there. Your Lordship, this is the payment.
Mr. Majumdar, if you do not answer the question of the
Yes.
court, the court will not answer your grievance.
Yeah.
I am asking you, if your client has received compensation for the land, showing it to be a non-forest land, where is the order for payment of compensation?
Your Lordship, may Your Lordship kindly see Annex 9, the affidavit in opposition filed by the National Highway Authority.
So you
There
don't,
they have
you don't
admitted.
have the order of payment of compensation.
Yes,
Why you don't have it?
I have the accounts, the payment that has been made. These are the
No,
payment
but why you have not produced the order of payment of compensation?
that I can produce, Your Lordship.
Produce it.
Even I have not annexed it, Your Lordship. That was what happened, Your Lordship, for
You
expand.
produce it on Friday, we'll keep it. Tell your officer not to take any action.
very well, Lordship. I
Till
produce the
Friday.
records on Friday, Your Lordship.
Till Friday, we'll post it on Friday. You show me the order for payment of compensation.
Why I have not annexed, Your Lordship? It is an admitted fact.
No, you have, these are not good things, what is happening. Why you have not shown the order and you have shown the bank statement?
That was
What explanation you have
correct in
put?
the compensation case that
So,
has been annexed.
so it should not be a next year.
I will go through that.
On the request
That
of
case,
Mr.
Your
R.
Honor.
Majumdar, Learned Counsel for the petitioner, this matter is directed to be posted again for motion on Friday, give the date. so as to enable him to produce the order by means of which land compensation was awarded to the petitioner for the plot of land in question. In the meantime, Mr. R. Gogoi, Learned Standing Council, Forest Department, Assam, to also obtain instruction and appraise this court. If the plot of land in question falls within forest area, and if so, in exercise of power under which provision of law the impugn notice has been issued. The instructions shall be made available in writing by the concerned
Range
DFO.
officer, Lord.
Concerned
DFO, Your Lordship.
Concerned DFO. List again on slides. Yes, who all are there? Ms. R. Bora, Learned Standing Council, NHA, DSCL.
National Highway Authority. Next,
लिखी दीपो Biomedical and Standing Council Revenue. Assam. Miss R. Bora, Learned Standing Council, NHA, IDCL are also present on behalf of their respective councils, respective clients.
Your Lordship, respondent number 5 is the deputy commissioner. He can also obtain instruction, whether it is a forest land or government.
You also verify. Mr. Handick to also obtain instruction from the deputy commissioner of the district.
Yeah, please, Your Lordship. Lordship, here is the case, my lord, during the pendency of civil suit, my lord. Now this municipal board has issued notice, my lord, and the same litigants in the civil court, my lord, and on the basis of the same complaint of the litigants, that plaintiffs, my lord, since they obtained the temporary injunction behind my back, my lord. So when I come before Lordship, this honorable court set aside the ex parte order. Then, my lord, what they did, then in earlier occasion also they made complaint. Now, when the parking slot, my lord, this parking space, my lord, that part already been sub judice before the learned court of Munchip number 1 at Pinchukia, my lord. Now, my lord, this notice has been issued, my lord, pendency of the suit, my lord, Lordship will find at page 51, Lordship. How can it be? Parallel proceeding cannot be run, my lord. Govinda to Govinda Karmakar and Srimati Uma Karmakar, my lord, final notice to suspend construction work until further order. Complaint. My lord, married, Lord.
Yes.
We refer to our earlier notices being number so and so dated 6/12/2022 and subsequently had our reminder notice being number so and so 13/7/23. Whereby you have been directed to stop construction activities till verification of proper parking place in your proposed building. In response to the same, we have received your reply dated 15/7/23, which is vague and the contention thereby are not admitted. The allegation level in your letter against the undersigned are also seriously viewed. Our concerned staffs have today physically verified the proposed alternative parking place proposed by you, as stated in your aforesaid letter, which cannot be considered in any terms. The two shops proposed by you in your said building for parking are also not enough space to accommodate any vehicle, and it is not as per approved drawing. In view of above, you are hereby hereby directed to this final notice to stop all construction activities in your building forthwith till providing the proper adequate parking space in your proposed building as per the approved drawing, else and the undersigned shall be constrained to take appropriate legal recourse against you without any further reference to on your cost and consequence, which is not. Now, whether this notice can be issued by the municipal board or not, Lordship have a look of written objection filed by the
All right, so at this stage, what is the relief you are seeking? Today, what is the relief you are seeking?
This stay, I pray for stay, my lord, of this impugn order.
Will stay, but you have to issue an undertaking or give a security that if you fail in the writ petition, it will be broken down.
Yes.
You are asking for final relief today.
Yeah.
You know the court will not grant it. Why are you asking for it? If this is stayed and you go ahead with construction,
My
this is
lord,
the final relief.
No, my lord, since my lord here on the basis of the permission given by the municipal board.
Mr. Chetri, I
Lord-
have understood your case.
Yes.
We'll have to issue notice to them and then pass a final order here. So
No,
talk on that. How the notice service can be expedited, when the matter can be fixed. You assist the court on that. This is not a matter where stay will be granted and matter will be
no,
kept. pending.
since Lordship is.
All right, we'll say it, but status quo, no construction. We'll pass this order.
Otherwise, but
Yes.
but
We'll stay this notice, but you cannot carry out any construction until further order.
Lordship is
You
very much.
cannot get a stay order and go on construction, expert stay order.
Now problem is this, my lord, since when I'm constructing the second floor as per, my lord,
Mr. Chetri,
Lord-
why is it so difficult always to understand the very, very elementary principles of law? This is the final relief you want. You want to carry on with the construction. You want that to be granted by an interim order. Tomorrow, if the writ petition is dismissed, then what will happen?
Lordship will then finally hear them because I'm suffering, my lord.
Is that
Any
what
day-
this is what I said.
Any day, lordships, my lord, since I need, my lord, this finality of the order, my lord, because this construction which was permitted by the municipal board, my lord, that has been stopped in earlier occasion by the court, my lord. Then that has been vacated. Now again, the same litigants has approached the municipal board repeatedly, my lord. Now this municipal board again, pendency of this
So
writ petition.
civil court has vacated the earlier injunction order.
Yes. And subsequently, again, they took behind my back the ex parte order.
Acha, have you made the complainant a party here?
No, complainant, my lord, here, my lord, only this in reference to their complainant, they have this notice has been issued. But since the notice was issued by the
So
municipal
in
board,
this matter, the complainant has nothing to do.
nothing to do.
Nothing to do. Be sure what you want to say. If you say the complainant has gone behind the back, you have not made him a party. If you say the complainant has nothing to do, then this matter has nothing to do with the civil case. Make up your mind, 15 minutes. You have to take a stand before the court, Mr. Chetri. Otherwise, it becomes difficult for us to also pass an order.
Lordship.
Are you saying that this exercise is actuated by or triggered by the private respondent? Yes or no? Yes or no?
Yes.
Then you have to make him a party. You have to make him a party, you have to implead him, you have to make pleadings against him, which you have not done. Withdraw it and file it on Wednesday. That will be the shortest route for your client. Other everything else will be very lengthy. Think about it. The court is trying to help your client, provided you are with an open mind.
I'm always open minded.
They'll come and say,
Clean hands, my lord.
they'll come and say
Lordship.
that we did it because we got a complaint. Then the matter will be further delayed. You have to implead him and he has to be served notice. He has to come. Then only an order can be passed. Why have you not impleaded him?
So only in the present case also, lordship will allow that part, my lord.
Allow
if-
what?
If he has to be, if they have to be impleted in the case, my lord.
You don't have any pleadings. What will you do with impleadment? There is no allegation against the private respondent.
No, that allegation has been made. On the instruction of the complainant and the litigants of the civil court, my lord. Now, again, on the basis of their complaint,
Acha, Mr. Chetri, see, these are serious matters. We understand the litigants are suffering. But you please think about the matter and take a stand, because these are legal issues which will stare at the face today or tomorrow.
yes.
Then you will find that the court proceeding is getting stuck up and all. So now onwards, the court proposes to write down everything in the order, that this has happened, this has transpired. The learned counsel has refused to change it. So therefore, these aspects will freeze now. When the final matter is taken up, finally, no further liberty will be granted. We have to write all these things. Why aren't you rectifying the defect and file it again? Matter becomes simple. You don't want to do it. All right, I heard Mr. B. Chetri, learned counsel, appearing for the petitioner, assailing the notice dated 9/8/2023, by means of which the petitioners have been asked to suspend construction work until further order. This writ petition has been filed. According to Mr. Chetri, The impugned order has been issued behind the back of the petitioner and at the instance of a private person who was instrumental even on earlier occasion in stalling the construction, which had led to institution of title suit number
68 of 2022.
68 of 2022 before the court of
Munship number 1, Tinsukia.
Munsif number 1, Tinsukia. Full stop. As such, contending that the respondent number 2 does not have the jurisdiction and authority to run a parallel proceeding in the matter, more so when a civil suit is pending, wherein the order of injunction restraining construction has already been vacated. The impugned notice is not maintainable in law. Full stop. From a perusal of the writ petition, I find that although there are allegations made against a complainant, he has not been included as a party to the writ petition. Full stop. Moreover, the prayer for interim relief suspending the order dated 9/8/2023, in the opinion of this court, would be in the nature of final relief, which cannot be granted without service or notice upon the respondents. Full stop. Mr. S.S. Roy, learned
For respondent number
government
2, Lordship.
appearing for Mr. J. Henry,
For respondent 1.
learned standing counsel, Revenue Department, Assam,
No, no,
appearing for respondent number 1,
Lordship, it is
Municipal.
not
Yeah.
the revenue department, but a
Municipal.
municipal.
Municipal Administration Department, Assam, has appeared for respondent number 1, and Mr. S.S. Roy, learned stand. Why, what do you have to say on this?
Lordship, before issuing this notice, Lordship, notice has been issued to him after receiving the complaint, Lordship. Thereafter, there was a settlement meeting between the parties, not to construct the upper side of the barn. You can construct the roof, but when we have currently come to that impugned notice, Lordship, our concerned staff has visited the site and see that that proposed parking which was given to him, it was not adequate to that, Lordship. Thereafter, Lordship, a civil suit also pending which for that, Lordship. Thereafter, this notice was given because he has violated the condition, Lordship.
And pray for some time to obtain instruction by contending that the impugned order has been issued after proper verification of facts and upon providing sufficient opportunity to the petitioner. Full stop. In view of the above, issue notice of motion returnable on 8th of September, 9th of September. Yes.
At the earliest, my lord, yes.
9th of September 2023. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the Land Department Council so as to enable them to obtain instruction and file affidavit. Prayer for interim order will be considered on the returnable date. Prayer will be considered on the returnable date. Yes.
Your Lordship, the matter will be, my lord, finally disposed of, my lord, on that particular day. Otherwise,
This matter will not be disposed even in 24. You have not implemented the complainant as a party. You have to file an application, get him implemented. I was giving you some good advice, you have not accepted it. Now you take your call. It will not be disposed of even next year, I am telling you. When next day when it comes, they will ask for time. Then when they file affidavit, the court will ask, why is private respondent not a party? Then you will say, I'll file an application. Then your application will be listed after 2 months. Then the court will allow impediment and issue notice. He will come and ask for time. And then he will file affidavit. Then he will seek adjournment. You are looking at 2025, Mr. Chetri, and this is all your creation. You are not happy, but what can be done? Law will go as per its own track. Can't help it. We can't help it. The easiest way for you would have been to withdraw it and file.
yes, yes,
Day after
yes,
tomorrow. Huh?
as your Lordship suggests.
Next matter, please.
Yes,
No, I will not pass it on.
May I please, Your Lordship? Madam, this is the matter for non-payment of compensation, madam. That has been decided and by the authority to divide the compensation of the land, which land has been acquired for the construction of the 4 lane in the Mongoldoy, Dorong, my lord. But what happened, my lord, the entire amount, 2 land has been acquired, my lord. One is 1676, the dark number, another is the 1671. 1676, my lord, the compensation amount is 5,07,022. It should be divided equally in two share, my lord, but that has not been done, and entire amount has been deposited to the respondent number 5, my lord.
Who is the respondent number 5?
The respondent number 5 is the person, my lord. He is under the plot, my lord, who has been illegally acquired by him, and at the time of
We
the.
have to issue notice here.
Yes, my lord.
Mr. D. Borua, learned counsel appearing for the writ petitioner, alleging illegal disbursement of compensation in favor of the respondent number 5 for the land, for acquisition of the land in question.
Yes, sir.
The instant writ petition has been filed, inter alia contending that a portion of the compensation is liable to be paid to the petitioners as well. Mr. Ms. N. Bordeloi, learned standing counsel, Revenue Department, Assam. Are you appearing in this case?
I'm for one.
Appearing for respondent number 1 and Mr. H. Sharma, learned additional senior government advocate, Assam. Appearing for respondent numbers 2, 3, and 4, pray for some time to obtain instruction and file affidavit. NOM 4 weeks. Since respondent numbers 1 to 4 are already represented, no formal notice is required to be sent to the said respondents. Extra copies of the writ petition be furnished to the learned department counsel so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 5.
No, here I have a small pair, my lord. In the compensation in respect of land, that number 1676 is not finalized. It should not be finalized till the disposal of this case, my lord. It is not deposited.
Also heard on the prayer of interim relief, this said will be considered on the return date.
Oblige, your lordship.
Item 14.
Please, lordship.
Page 20, lordship. Now, this was the application submitted by the petitioner in before 1 year, lordship, on 16/7/2022, lordship. My lord, the authorities, my lord, is sitting over the matter, lordship, despite repeated approach.
What is the relief you want?
Sorry, lordship.
What is the relief you want?
My lord, it may, my lord, circle officer may be directed to
Demarcation
decide
is
the
a
matter, my lord.
notified
And
Demarcation is a notified service, your worship.
Why don't you find out what has happened? We'll have it on next Monday. Next Monday for motion. Heard Mr. M. Ahmed, counsel for the petitioner. The petitioner is aggrieved due to inaction on the part of the concerned revenue authorities in acting on the application for
Circle officer,
demarcation. Due to the inaction on the part of the concerned circle officer. That is respondent number
Respond number, lordship, 4.
4 due to his failure.
3,
to-
3, your lordship, 3.
Respondent number 3 due to his failure to act on the application for demarcation of land submitted by the petitioner. Ms. Bordelais submits that demarcation is a notified within course notified unquote subject, and therefore should be granted a week's time to seek instruction and approach this court if any action has been taken in the matter in the meantime by the respondent number 3. Prayer allowed. One extra copy of the writ petition be furnished to Ms. Bordelais. Let this writ petition be listed for motion again on Monday.
Oblige.
Monday will be what? 28.
oblige.
At page 29, lordship will find the order passed by the learned Ombudsman.
Ombudsman is banking ombudsman.
My lord. Page 29. This is regarding lord. And property part, my lord, page 31.
So one of the order is of 26th of December 2023.
This is my lord, 21/12/2022.
See the first line of your synopsis.
Sorry, my lord.
Where is the order? Where is the impugned order?
Page 29. my lord. 21/12/2022.
Mm. So notice has to go. I heard Mr. M.O. Mondal and the counsel for the writ petitioner assailing the orders dated 15/2/2022 and 26/12/2022 passed by the insurance ombudsman, that is the respondent number one, rejecting the claim of the petitioner. The instant writ petition has been filed. I have perused the amendments made in the writ petition. NOM 6 weeks notice by registered post.
Brother, they may be permitted to correct this. Yes, obviously.
I wanted to call, there is another matter.
Yes,
No, okay. Which is your matter?
item 6, madam.
Item 6.
6, no? 6.
Is the Passover matter. Yes,
My lord,
116.
Rule, my lord, we are referring, my lord. Yes.
Hmm. You want the names of respondent numbers 7
And 8,
and 8 to be struck off.
my lord.
In respect of which land?
My lord, that is, my lord, we have given, my lord. Tag number 139, old. Page 22, lordship will find. New, my lord, 150, Kotian number 94. Here's Mehdi Patta number.
Land measuring 4 bigger 2 kathas.
My lord. Page 22, lordship will find.
So
Yes.
we'll ask the deputy commissioner to examine their grievance and pass appropriate orders in the light of rule 116 of the regulation. Take down hard, Mr. Will dispose it of.
Right.
Mr. M.O. Mondal and the council appearing for the writ petitioners. Also heard writ petitioner. Also heard Ms. G. Hazarika, learned standing council, Revenue Department, Assam, appearing for the respondent numbers. Respondent number 2. First of Mr. H. Sharma, learned additional senior government advocate, Assam, has appeared for respondent numbers 1, 3, 4 and 5. 4, 5 and 6. First up. The writ petitioner hearing claimed to be the legal error late Moiful Bibi.
Moiful Bibi.
Late Moiful Bibi, wife of late Muhammad Ali, who was the absolute owner of a plot of land measuring 4 bighas, 2 kathas, covered by dag numbers 139, bracket old, stroke 150 new, dag number, not numbers, of Khotian number 94, pertaining to Kheraj Miadi Patta number 105 of village Bashir Char under Bauraguri Circle Office in the district of Kokrajhar, Assam. Full stop. According to the petitioner, the name of the respondent numbers 7 and 8 are required to be deleted from the record of rights pertaining to the above land, since they do not have semblance of right, title and interest over the plot of land in question. Full stop. Notwithstanding the same, and despite the application dated 21/11/2022 submitted by the petitioner before the Deputy Commissioner Kokrajhar, that is the respondent number 3, praying for deleting the name of the private respondents, no action has been taken in the matter till today. Stop. Hence this writ petition. By referring to the provisions of Rule 116 of the rules framed under the Assam Land and Revenue Regulation, 1886, Mr. Mondal submits that the Deputy Commissioner of the district has the power to order that the name of a proprietor be struck off of the register whenever it comes to the notice of the deputy commissioner that any person whose name is recorded therein is no longer in possession of any such estate. Notwithstanding the same, no action has been taken in the matter. Full stop. The learned departmental counsel have submitted that if there is provision in the rule permitting the deputy commissioner to take action in the matter, a direction be issued to the concerned authority to examine the grievance of the petitioner and take appropriate action in the matter. Mr. Mondal has also agreed to such a recourse. In view of the above, without expressing any opinion on the merit of the case projected in the writ petition, insofar as the claim of the petitioner over the land is concerned, this writ petition stands disposed of by providing that the respondent number 3 may examine the representation dated 21/11/2022 submitted by the petitioner and take appropriate action as may be permissible under the law. Full stop. If on verification of facts, it transpires that the issue projected in the writ petition raises a civil dispute and therefore requires adjudication by the civil court, it will be open for the concerned authority to express such an opinion in writing by giving proper reasons. With the above observation, the writ petition stands disposed of.
Deputy Commissioner Malad, take note of this matter after hearing the respondent number 7 and 8 also, Malad.
It is made clear that before taking any decision in the matter, the respondent number 7 and 8 may also be heard. Writ petition stands disposed of. This is going to civil court, Mr. Mondo.
Yes, yes.
So what is happening is all these matters are getting stuck up. Unnecessarily writs are being filed, then notice goes, counter. I've been saying this since morning.
Yes.
Counter comes. After 3 years, 2 years, the court says go to civil court. And the litigants feel, what is this?
Now, civil
So
court
many
also,
years gone. And it's
uh,
all happening
will
because.
take Malad so much time. So Malad, they are.
But it will take ultimately.
Yes.
Whatever time it will take, plus this additional 3 years. Because you don't want the matter to be expedited. As simple as that. This is a civil dispute. They will say that we have right over the land. How can the deputy commissioner, if the deputy commissioner passes an order in your favor, they'll come to the high court and say it's a civil dispute.
Yes.
These are all very known models. But you are happy because cases are coming. All right. Yes.
Finding matter item 3.
May I please, your lordship? So, my lord, I like to withdraw this matter, my lord,
Withdraw.
and file before the.
Are you convinced that this matter should go to district judge?
Yes, my lord.
Huh? If you are not convinced, then I will hear you again.
No, my lord.
Don't have to hurry. But you will not get any relief in the writ court.
Okay, my lord, we will file before the session.
All right, your name, please.
Abdul Ghani. Hey, Ghani.
I heard Mr. Abdul Ghani, learned counsel, appearing for the writ petitioner. The petitioners are aggrieved by the petitioners are dissatisfied by the amount of compensation paid to them due to acquisition of their land for laying down gas pipeline.
BGPL pipeline.
BGPL means
Barauni Guwahati pipeline.
Pipelines.
Barauni Guwahati pipeline. Bracket BGPL. Full stop. Miss G. Hazarika, learned Miss N. Bordoloi, learned standing counsel, Revenue Department, Assam, as well as
S.
Mr.
Mitra.
S. Mitra, learned standing counsel, GAIL, are present. Mr. Mitra submits that a dispute of this nature can be adjudicated by the district judge under section, where is this? Give it to me. Under section 10, subsection 2 of so and so act. At this stage, Mr. Goni seeks leave of this court to withdraw this writ petition with liberty to his client to approach the Court of Learned District Judge, which district?
Kamrup.
Kamrup, rural or metro?
Rural.
Rural,
Yes, ma'am.
by filing appropriate application under section 10(2) of the Act of Act of 1962, we'll get it here. In view of the prayer made by Mr. Goni, this petition stands disposed of on withdrawal with liberty as prayed for. The name of the act, you will get it here, the Petroleum and Minerals Pipelines, bracket, acquisition of right of user in land, bracket, was Act 1962.
Deeply
Obliged, Lordship.
See, this will save your client's time.
Yes.
We had to say this because I can issue notice and let it pending, but
It will take more
it will
time.
take more time.
Yes, ma'am.
You must understand these things.
Yes.
Yes.
Deeply obliged. ma'am.
Obliged, Lordship.
Item 16.
May I tell the Lord, my lord, the petitioner is the only trade union body of ONGC workers in Kachar sector, madam. One of the members of the said union, general member, posed letterhead of the union and formed a parallel committee regarding which we submitted a complaint before the authorities, before response number 4. And response number 4 rightly replied at page 28 that, but page 28, point number 2, that shall not interfere. And that was the position.
Where is the order dated 17/7?
Yes, my lord, at page 31, this is the impugn order. After this order has been passed, sealing the office of the union. Page 31. We are aggrieved by this one.
No, so they have only, because of the dispute, they are not allowing you to use the property of the ONGC.
My
That's all.
lord, one person actually, he was against us. He filed some forged letterhead. I have annexed it. And my lord, annexed.
Mr. Madhavya,
Yes.
please listen to the, if you don't want to understand, it's fine. You
Yes.
listen to the query of the
Yes.
court. Huh? I know you are holding a brief, you have to deliver, I know that. But you see, the notice says that because there is a dispute between two factions of the union, trade union, the ONGC says, we will not allow you to use our premise till the dispute
This
is.
findings, this premise that there are two factions.
Ah.
This is wrong, my lord. And even if there are two factions, that can be decided only by response number 5, my lord. Chief Labour Commissioner.
Correct.
So we are approaching Chief Labour Commissioner regarding our internal dispute. We are aggrieved by this. The authorities cannot stop the union office. It is in a legally formed body. There is no other union.
Will you allow, but the other faction to operate, not him.
I am applying response number 1.
Yes.
2, 3 and 4 ONGC, your lordship.
Who is for the ONGC?
On behalf of GNC.
Allow the other faction to operate the office. You are agreeable to that?
Notice may go on.
Notice may go.
Yes.
No interim required.
Not
All right. I heard Mr. NH Madhavya Raj, counsel for the petitioner, assailing the office order dated 17/7/2023, issued by the respondent number 3, sealing the office of the TUOW on the ground that there is a dispute between two factions of the office bearers. The instant writ petition has been filed. Mr. Madhavya submits that in the event of a dispute between the office bearers of the trade union, it is only the response number 5 which has the jurisdiction to look into the matter. Full stop. Therefore, the impugn order issued by the response number 3 is wholly arbitrary and illegal. Full stop. Mr. PK Mehdi, learned CGC, appearing for respondent number
One.
1, and Miss K Bhattacharya, learned counsel for respondent numbers 2 to 4, have prayed for some time to obtain instruction and file affidavit. Similar is the prayer of Mr. H. Sharma, learned additional senior government advocate Assam. No, you are for 1 and 5 then. Labor Commissioner is Government of India.
Lordship.
1 and 5. Good. In view of the above, issue notice of motion returnable in 4 weeks. Since the respondent numbers 1 to 5 are already represented, no formal notice is required to be sent to them. Extra copies of the writ petition be furnished to the learned department council within 3 days from today, so as to enable them to obtain instruction and file affidavit. Petitioner to take steps for service of notice upon respondent number 6 by registered post with AD within 3 days from today. Heard on the prayer of interim relief. Since Mr. Magar Bhuya has submitted that his clients have already approached the respondent number 5, the prayer for interim relief will be considered on the returnable date. Leave the matter accordingly.
Object.
Give this book to everyone.
Your Lordship.
Yes.
Lordship, matter relating Lordship, ex gratia Lordship. Matter regarding ex gratia Lordship.
Ex gratia.
The husband of the petitioner died on a road traffic accident, Lordship. And this honorable court recently passed an order, Lordship.
The NOK has not been annexed, Your Lordship.
In the motion, I will not dispose of ex gratia.
Yes,
So you obtain instruction.
NOK is not annexed.
NOK.
Yes, next of kin certificate.
You have the NOK.
Lordship, in this judgment, this honorable court passed an order, Lordship.
I will not dispose of this matter, whoever passes what on.
NOK, no.
Financial matters not in the first day. But
Lordship,
where
we
is
have
the
not-
NOK?
We have not annexed, Lordship.
Why?
We have,
See, you are delaying the relief to your client. That's what I'm trying to say. The court is in a hurry to grant relief. You are the one who is delaying it. Next date you will file. Again, take time for NOK, then you will file it. Then they will seek instruction. 6 months gone. You don't have the NOK.
we have to apply, Lordship.
Huh?
We have to apply.
They have to
You have to
apply.
apply.
They may file an additional affidavit, Your Lordship.
Then you apply and
Yes.
bring it on record.
Yes, Your Lordship.
Yes, Lordship.
Otherwise, there will be delay in your matter.
But in this judgment, Lordship, there is no NOK required.
That judgment was passed on the motion stage.
Yes.
That is not in motion stage. You don't understand simple language. This is a motion matter. That was an admission. You obtain instruction. Your name, please?
Yes, Lordship.
Mr. K. Jamal, learned counsel for the petitioner. The husband of the petitioner died in a tragic road accident on 27/5/2022. When the application seeking ex gratia amount of rupees 2 lakhs was denied to the petitioner, the instant writ petition has been filed. Miss N. Bodole, learned standing counsel, Revenue Department, Assam, prays for some time to obtain instruction. NOM 6 weeks. Since Ms. Bodole has appeared in accepting notice for respondent numbers
2, Your Lordship.
Respondent number 2. Mr. H. Sharma, learned additional senior government advocate Assam, for respondent numbers 1, 4, 5, 6, and 7. And Mr. B. Gogoi, learned SC Finance, for respondent number 3. Service of notice is deemed to be complete in this case. Extra copies of the writ petition can be furnished to the learned department council so as to enable them to obtain instruction. Liberty is also granted to the petitioner to bring on record the next of kin NOK certificate by filing additional affidavit, as and when the same becomes available to her. The learned departmental council to obtain instruction facilitating disposal of the writ petition at the stage of admission hearing. List this case again by reflecting the name of learned departmental council in the cause list. You get the NOK. Yes.
I am obliged to.
Item 19.
Wait, please, your lordship. My lord, petitioner, my lord, your lordship, my lord, is the my lord, president, my lord, the newly elected constituted board of directors, my lord, of Rosnavari Samavai Samati Limited in the Moria district, my lord. What my lord, basically, he is agreed, my lord, by order, my lord, and this your lordship will find that page 69, my lord, issued by the Register of Cooperative Society, my lord. Yes, my lord, this order was passed, my lord, in terms of a determination filed by one suspended secretary of the Samavai Samiti, my lord. And here is this allegation, my lord, on which the approval of the my lord BOD was rejected, my lord. Can you see? They have said that my lord, page 70, my lord. Yes, the allegation
So
is
what
that,
is the relief you want today?
my lord, I twisted this operation of this impunity, my lord. There was
Your
notice-
client was in office before 19 July.
My lord.
Since 19 July, he is not in office.
Yes, yes, he was in office. He was in office.
After this order cannot be.
After this order, no, my lord. Like before 19, he was in office. He was the chairman of the, my lord. Board of
Correct. So he has been out of office since last 1 month.
My lord,
We'll issue notice and hear it.
my lord, kindly, I issue this, my lord. Kindly, my lord.
Had
Because
Mr. S. Hawk learned counsel appearing for the writ petitioner, assailing the order dated 19/7/2023 issued by the Register of Cooperative Societies Assam, that is the respond numbers,
Respondent number, my lord,
respond number 2,
two, my lord.
holding that the election of the petitioner as the president of
Not only the petitioner, my lord, board of director,
Uh,
as an election, my lord,
holding
as a
that the
board
election of the board of directors
of the Losanabar Samaj.
of the Losanabari Samabai Samiti Limited held on 22/12/2022 was illegal, is illegal. The instant writ petition has been filed. Inter alia contending that the impugned order dated 19/7/2023 is illegal and hence liable to be interfered with by this court. Mr. S.K. Talukdar, learned standing counsel, Cooperative Department, Assam, prays for some more time to obtain instruction in the matter. Issue notice returnable in 4 weeks since Mr. Talukdar has appeared and accepted notice for respond numbers 1, 2, 3, 4 and 4. No formal notice is required to be sent in this case. Extra copies of the writ petition will be furnished to the learned department counsel so as to enable him to obtain instruction and file affidavit. Some people had made a complaint, is it? That
It appears, madam.
Hard on the prayer of interim relief, this said prayer will be considered on the return of the Yes.
My lord, just 1 minute, my lord. What happened, my lord, in this case, my lord? On the ground on which this order was passed, my lord, the allegation was that the election was held at 9 AM, my lord. And on that day, my lord, the meeting was held at 9 AM as per legal, my lord, election law, my lord, election rule of the Cooperative Society. After conducting the general election, AGM, my lord, the election proceeded, my lord. Now, this is the baseless, my lord. Well, at 9, how election? Can you see the, my lord, only one line, my lord?
Mr. Hawk,
My lord,
somebody has made a complaint.
my lord, my lord,
Is it not?
my lord.
You will not get any relief even on the next date.
Yes,
Because you have not impleted
Not
them.
completed. That is.
These are fundamental things.
My
The
lord.
lawyers are making
Yes,
mistake
my
what to
lord.
do. Yes, next matter, please.
My lord.
Obliged.
Oblige, my lord, oblige.
If you don't know how to file
My
a
lord,
writ
my lord, my
petition,
lord.
that is your
My
problem.
lord,
You have not impleted them. There is no averment against them. You want an interim
no,
order
my lord,
only.
I have not, my lord, on that plea, my lord, he was not against the person who had complained, my lord. He was not against the board of director, my lord.
Whatever it is, his complaint has been taken note of and your election has been declared as illegal. You don't even implement him as a party.
No,
These are
not
fundamental lapses in a writ
He-
petition.
My lord, that
All
person
right, all
even
right.
did not challenge the election, my lord.
Oh, we'll hear it.
My lord.
We'll hear it in due course.
My Oblige,
If you want an interim order, you have to make him a party.
my lord. Oblige.
Yes,
Well,
Mr. Kotapi.
This is before lordship, my lord, they are the tenants of the respondent number, private respondents, my lord.
Hmm.
Way back in January, February, my lord, they refused to receive rent. So we started paying in the court, my lord, civil court. Now, what happened, my lord? Thereafter, they started harassing us, so we obtained an order of injunction also. Now, thereafter, they forcibly want to vacate me, then FIR was filed, and the counter FIR also filed. Now, what happened is fine. This some police officials, my lord, they have been made party by name, my lord, there is 5 and 6, my lord. They started harassing us. They wanted that we should settle the matter and leave the premises. Right? And though we approached the commissioner of police, my lord, against them, my lord, but nothing has been done. Commissioner, please.
What is the order you are seeking?
The order is saying, my lord, basically our case that in the name of investigation, my lord, we should not be harassed, my lord. That's the
Who has harassed you?
this police officers, my lord. That's
Where is the statement?
statement you will also find. Paragraph 11, my lord.
So you say that police is harassing you.
Yes.
How is it harassing you? When you go to them, they don't take any action against the other party.
Yeah,
So what kind of a stand is this?
They are saying that you get the premises.
How is it harassment?
But you know, already instead of investigating the matter, we have been assaulted and subjected to.
No, why a police case has been registered?
Yes, ma'am.
Then
Police has been registered, but nothing has been done as well.
we'll issue notice returnable.
Yes,
in
that-
Third, Mr. P. Cottaville and counsel for the petition. There will be amendments made in the writ petition. Issue notice returnable in 4 weeks since Mr. H. Sharma and government additional senior government advocate Assam has appeared and accepted notice for respond numbers 1, 2, and 3. No formal notice is required to be sent to the said respondents. Extra copies of the writ petition be furnished to the Land Department Council. Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD within 3 days from today. List the matter after 4 weeks for necessary orders. On the next date fixed, Mr. Government Advocate Assam to obtain instruction and appraise this court as to the progress made in investigation carried out in connection with the Persistent PS case number 439/2023, registered under section 448/427/384/506/34 of the IPC, based on the Azahar dated
As I dated to 26/7, man.
26/7/2023, lodged by the petitioner. So 26th of July, Azahar was lodged.
Yes, ma'am.
Your grievances investigation has not been concluded till today.
No, nothing has been done.
You have to finish your investigation in 48 hours now. Otherwise, people
They
will
are
come
they are
before.
pressurizing us to leave it, my lord, to settle the matter. Either they are going to appear before the civil court, my lord, because civil court will take time, my lord. That is the difficulty. My lord.
Okay, let him appeal.
Till then, my lord,
Till then what?
no coercive action, nothing.
No, they can't take any coercive action.
That's it.
May I please, your lordship, the petitioner land was acquired by the National Higher Authority. Then when a compensation was not given, then we approached this honorable court. Honorable court directed to complete the process within 6 months. But thereafter, my lord, they have initiated the process. In July 2020, my lord, some assessment was made, the amount was fixed. It was sent to the National Higher Authority. That was thereafter nothing was done. COVID came. Then we again approached the National Higher Authority by filing representation. We filed representation for the Deputy Commissioner also. Nothing was done. Then we approached the Ministry of Transport, Highway and Transport, Union of India. Then also nothing was done. This is the stage, my lord.
So basically, they have not paid you compensation. So what we'll do is we'll issue notice and ask them to come up with the stand, then we'll pass a mandamus. For Mr. N. Hawk, learned counsel appearing for the writ petitioner. the petitioners are aggrieved due to non-payment of compensation for acquiring their plot of land for construction of highway. Full stop. I have perused the amendments made in the writ petition. Issue notice of motion returnable in 6 weeks. Who is appearing for who?
For respondent number 1.
Since Mr. A.G. Gupta, Learned CGC has appeared and accepted notice for respondent number 1. Ms. N. Bordoloi, Learned Standing Council, Revenue and Disaster Management Department, Assam, for respondent number 2. Mr. H. Sharma, Learned Additional Senior Government Advocate, Assam, for respondent number 3. Anybody for PWD? Any standing council PWD?
B. Gogoi's name may be recorded. B. Gogoi.
B. Gogoi. And Mr. B. Gogoi, Learned SC PWD, for respondent numbers 4 and 5. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the Learned Departmental Council so as to enable them to obtain instruction facilitating disposal of the writ petition at the stage of admission hearing. Register to list this case by reflecting the names of all the departmental council in the court list.
May it please your lordship. Lordship, in this case, my lord, this writ petition has been preferred regarding termination of bid, my lord. Termination of bids.
Bid.
Yes, my lord.
Bench 4.
Hello?
Bench 4 matter.
Bench 4.
After hearing the preliminary submissions of Ms. M. Sharma, Learned Counsel for the petitioner, it appears that this writ petition pertains to civil bench 4, but it has been wrongly listed before this court today. Register to verify and list this case before the appropriate bench. Day after tomorrow.
May please. Matter pertains to non-payment of land compensation. What happened page 19, my lord. The report was there, at page 21 also there is report, my lord. But
So here also notice has to go.
my lord.
Notice
Pendency
to
may
notice.
not be, my lord,
All right.
down for my lord.
Heard Mr. P.J. Saikel and a counsel appearing for the writ petitioner. The matter pertains to grievance expressed due to non-payment of compensation on account of acquiring the land of the petitioner. I have perused the amendments made in the writ petition. NOM 6 weeks. Who is appearing for?
I am appearing for respondent number 2, lordship, standing.
Achha, who is for 1? Respondent number 1.
Your Honor.
Your name, please?
Deveta Manpung. NT Manpung.
Huh?
NT Manpung, Your Honor.
Heard Srimati so-and-so accepts notice for respondent number 1. Then who is for 2? Your
Lordship, I am VL Singh. lordship.
Miss VL Singh, Learned Standing Council, NHIDCL, for respondent number 2. Miss N. Bordoloi, Learned Standing Council, Revenue and Disaster Management Department, Assam, for respondent number 3. Mr. H. Sharma, Learned Additional Senior Government Advocate, Assam, for respondent numbers 4, 5, and 6. As such, service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the Learned Departmental Council so as to enable them to obtain instruction facilitating disposal of the writ petition at the stage of admission hearing. It is made clear that pendency of this writ petition shall not be a bar for the authorities to redress the grievance of the petitioner in accordance with law, if so advised. Yes.
See, revenue may be reflected in the causes.
Let the matter be listed by reflecting the name of Learned Departmental Council in the corporate.
Oblige.
May I please your lordship?
Ex gratia.
Lordship.
The matter pertains to claim for release of ex gratia compensation rupees 2 lakhs on account of accidental death of the father of the petitioner.
The son of the petitioner.
Son of the petitioner, which took place on 27/4/2021. Peruse the amendments made in the writ petition. Issue notice of motion returnable in 4 weeks since Ms. N. Bordoloi, Learned Standing Council, Relief and Revenue and Disaster Management Department has appeared and accepted notice for respondent number 1 Mr. B. Gogoi, learned SC Finance for respondent number 2, and Mr. H. Sharma, learned Additional Senior Government Advocate Assam for respondent numbers 3, 4, and 5. Service of notice is deemed to be complete in this case. Extra copies of the writ petition requisite in numbers be furnished to the learned departmental counsel so as to enable them to obtain instruction facilitating disposal of the writ petition at the stage of admission hearing.
Deeply obliged, Your Lordship.
Supplementary list for motion item 53.
Munia.
That's a time barred issues, my lord. My lord, in interpreting, I am providing your lordship two judgments, my lord.
Mr. Talukdar, are you aware of the judgments?
I
have seen those.
So this is all decided matter,
my lords.
One, your lordship has interpreted similar provision as regard Panchayat, lord, where the time limit is 60 days.
60 days.
And the petition was filed on 61st or 62nd days. Lord, the other judgment is from Apex Court, my lord, para 33, interpreting Bombay Municipal Act, my lord. It was there, the limitation was 10 days and it was filed on the 11th. The Apex Court has said, no, it can't be extended.
My lord, then accordingly, your lordship may can.
where is the impugned order?
My lord, page 38, my lord.
In fact, the tribunal has not gone into the limitation part. On the merits, the tribunal has rejected.
On the merits. Page 38, my lord, another
Acha, election was held when?
My lord, 6/3/2022.
6/3.
My lord. And results were announced on 9/3.
And when was the when was it notified?
My lord, on 9/3/2022. An election petition was filed on 18/7/2000.
111 days.
111 days.
111 days.
111 days.
My lord, 111 days. As per section 16 of the Municipality Act 1956, limitation period is 21 days. Am I correct?
16 of the Municipal Act, just give me the.
Section 16, my lord.
16. So earlier it was 21 days, is it?
Yes, it is now also 21 days.
Till date is 21 days. Act has been amended, but this limitation period has remained the same.
Sorry?
Yes, my lord.
Till today it is 21 days.
21 days, my lord.
But it was filed 111 days there.
After 111 days, my lord.
And then your client had filed an application for condonation of delay.
Condonation of delay, my lord. Miscase number, it was miscase number 20. And he has also given explanation showing the cause of delay, my lord. Page 25 is a miscellaneous application.
No, the learned district judge says there is no reason, but even if reasons are given, it
Yes.
cannot be condoned.
The limitation period has not been considered, but they have, the tribunal has decided on merit of the contention so far as limitation is concerned. This aspect was not gone into.
The reasons have been, my lord, given at paragraph 3, my lord. That one family member was in a very critical condition. And he was,
But it cannot be done. Once 21 days goes, it is over. Nothing can be done. Heard Mr. A.R. Talukdar, learned counsel appearing for the writ petitioner. Also heard Mr. R. Dubey, learned standing counsel, Assam State Election Commission, appearing on behalf of the respondent number 1, Ms. M. Burman, learned Government Advocate Assam for respondent number, and Ms. M. Burman, learned Government Advocate Assam for respondent number 2. By filing this writ petition, the petitioner has assailed the order dated 23/6/2023, passed by the learned District Judge Kachar in Miss Case number 20 of 2022, dismissing the election petition filed by the writ petitioner, calling into question the election of respondent number
Maybe 4 minutes.
respondent number 4
4 minutes. Yes.
as a ward commissioner of ward number 6 of Sonai municipality. Petitioner was a elector or was a contestant?
Contested.
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 It appears from the materials on record that the elections to the Sonai municipality was held on 6/3/2022, wherein the writ petitioner was also a contestant. Full stop. The results of the election were declared on 9/3/2022, wherein the respondent number 4 was declared to be the elected candidate. Full stop. As per section 16 of the Assam Municipal Act, 1956, the election petition challenging the election of a commissioner was required to be instituted before the concerned district judge within the period of 21 days from the date of declaration of the results. However, in the present case, the writ petitioner had filed the election petition after 111 days from the date of declaration of the results, but along with an application under Section 5 of the Limitations Act for condoning the delay. Full stop. It appears that the writ petitioner had also submitted some justification before the authorities in his attempt to explain the delay. However, by rejecting such explanation, the learned district judge had held that the election petition was barred by time. Full stop. Mr. Dubey has produced 2 decisions, namely the judgment of the Honorable Supreme Court of India rendered in the case of Smita Bhushan Sawant versus Jagdeshwari Jagdish Amin and others, reported in 2015 bracket close 12 SCC 169, as well as another decision of this court rendered in the case of Anjuwara Ahmed versus Najma Ahmed and 3 others, dated 16/12/2022, rendered in connection with WPC number 5006 of 2022, to submit that even 1 day's delay in presenting the election petition cannot be condoned under the law. Full stop. Under the circumstances, Mr. Dubey submits that there was no scope for the learned district judge to entertain the election petition beyond 21 days from the date of declaration of the results. As such, there is no merit in the writ petition, and the same is liable to be dismissed in limine. Full stop. In the case of Smita Subhas Sawant, bracket Supra, the Supreme Court, while interpreting a similar provision in Bombay Municipal Corporation Act, 1888, had held that delay in presenting election petition beyond the prescribed periods, beyond the statutory period, even if it is for 1 day, cannot be condoned. Full stop. In the case of Anjuwara Ahmed, a similar view has been expressed by this court in the context of This is Assam
Panchayat Act, my lord, the 60
Assam
there, the
Panchayat
validity
Act
was 60 days.
94, wherein it was held that an election petition presented beyond the statutory period of 60 days was not maintainable, and there was no scope for condoning the delay in filing such election petition by invoking powers under section 5 and 14 of the Limitations Act 1963. First up, having regard to the facts and circumstances of the case, this court is of the opinion that the ratio laid down in the aforesaid two decisions would be squarely applicable to the facts of the present case. Mr. Talukdar also could not refute the above contention of the learned standing counsel for the respondent number 1. In view of the above, I am of the opinion that there is no merit in this writ petition. The same is accordingly dismissed in limine.
My lord, respondent number 3, I would be representing, my lord.
Actually, 1 and 3.
And my lord has indicated, my lord, it was filed after 111 days, but there was a delay of 111 days, my lord.
Actually, was filed with a delay of 111 days. That is 132 days.
Yes.
That is after 132 days from the date of declaration of.
This is also an identical case, but we have to take steps similar as per the earlier order.
What is the identical steps?
The rule 116 Miller. Yeah. Lordship, in respect of item number 6 Miller, Lordship has passed some order directing the deputy commissioner to pass appropriate order on the representation.
All right, then we'll dispose it of here also. Which district is this?
Dhubri district.
Huh? Dhubri.
And representation Lordship will find page 81.
Page 81.
Page 81.
All right, you take down. Heard Mr. M. Monroe, learned counsel appearing for the writ petitioner. Writ petitioners. Also heard Ms. M. Burman, learned government advocate Assam appearing for the respondent numbers 1, 3, 4, and 5. Full stop. Ms. G. Hazarika, learned standing counsel, Revenue and Disaster Management Department Assam, is present on behalf of the respondent number 2. Full stop. The writ petitioners hearing claim to be the absolute owner in possession in respect of a plot of land measuring 4 bighas 19 lesses. In respect of plot now, in respect of land measuring 4 bighas 19 lesses. And another plot of land measuring 4 bighas 19 lesses. So there are 3 plots, 4
Yes.
bighas 19 lesses, 4 bighas 19 lesses, and 3 bighas 12 lesses. In total, 3 different plots of land situated at village Barshi, part 2, under Bilasipara Revenue Circle in the district of Dhubri. The aforesaid plots of land Bilasipara Dhubri, what is the dag number and patta number?
Dag number, patta number, dag number 257.
Covered by dag number 1, only one dag number.
Another
257.
Another dag number 436. And patta number 8 and 9.
Patta number 8
and 9.
And dag number 436 of KP patta number 9. Full stop. The aforesaid plots of land were sold off by the respondent numbers 6 to 11. And therefore, according to the petitioners, the aforesaid respondents do not have any semblance of right, title, and interest over the said plot of land. Full stop. Notwithstanding the same, and despite the fact that the petitioners had submitted application dated 8/8/2022 before the respondent number 3 that is the Deputy Commissioner Dhubri, with a prayer to delete the name of the respondent number 6 to 11 from the record of rights. No action has been taken in the matter till today. Hence, this writ petition. According to Mr. Mondal, under section 1, under Rule 116 of the rules framed under the Land and Revenue Regulations 1886, it is the Deputy Commissioner of the district who has the power to strike off the names of those proprietors of the land who were no longer in possession of the estate. Full stop. These matters were today listed for issuing direction for taking steps upon the private respondents. However, the learned departmental counsel submits that since the representation filed by the petitioners is pending disposal before the concerned authority, the writ petition itself can be disposed of by providing that the matter be examined by the respondent number 3, whereafter appropriate decision be taken in respect thereof. First up, in view of the above and having heard the submission of learned counsel for both the sides, this writ petition is being disposed of by providing that the respondent number 3 may examine the application dated 8/8/2022 submitted by the petitioners in the light of Rule 116 of the Assam Land and Revenue Regulation rules, and thereafter take appropriate decision in the matter after examining, after verification of necessary facts. In doing so, the respondent number 3 may also give an opportunity of being heard to the respondent number 6 to 11. The exercise as directed above be completed as expeditiously as possible, but not later than 8 weeks from the date of receipt of a certified copy of this order. This petition stands disposed of.
For admission item 26.
Well, Lordship, please. The respondent has to file the affidavit. In the your Lordship will see the last order. That is, in case of not filing, the matter will be disposed of. There is an observation.
I have received instruction.
So you have filed an affidavit, he has received instruction, it will be necessary. How much time you want?
2 weeks, my lord.
2 weeks. Let him file the affidavit. I heard Mr. A. Upadhyay, learned counsel for the petitioner, also heard Mr. S. Rabha, learned standing counsel BTC, who submits that he has received written instructions from the concerned authority and therefore 2 weeks time to place the matter on record in the
Date
form.
may kindly be fixed.
Huh?
Date.
Why? Why?
The Lordship up to.
The date may be fixed, but why it should be fixed?
Otherwise.
No reason.
No, not, it will not be listed. That is the problem here.
Ms. M. Borman, learned government advocate Assam, and Ms. N. Bordelais, learned standing counsel, Revenue Department Assam, are present on behalf of the state. On the request of Mr. Rabha, this matter is directed to be listed again after 4 weeks. Affidavit on behalf of the BTC authorities be brought on record in the meantime by serving an advance copy upon the petitioner's counsel. Yes.
30 and 31.
Interim, there is interim order. that may-
Interim order passed earlier to continue. Yes,
Lordship, petitioner is a poor and BPL category people, and as per in the year 2011, as per procedural auto-generated priority list, they had been sanctioned PMGAY scheme, house scheme lordship. So after that, the Gao Panchayat was newly replaced, the newly member lordship, and the petitioner is deprived, and they newly prepared a new lease lordship, and the petitioner deprived in this scheme lordship. And annexure lordship. Annexure 3, page number 40 lordship, the new, the Gao Panchayat members are sanctioned the petitioner name lordship, and they had prepared a new list, which was page number 41 lordship, dated 15/5/22. My humble submission is that my this list may be considered lordship as per verification.
yes, Mr. Devnath, what do you have to say?
I know the petitioner talks about actually two lists. One contain the initial one containing of 244 numbers of beneficiaries. As far as that list is concerned, my lord, the instruction that I have says, my lord, so the 244 number, I mean, initially 244 and subsequently 55 numbers. The petitioners claim to have the name mentioned in the 55 list. The 224 number list mentioned by the petitioner in the is the Kacha House beneficiary list of Kanchanpur GP, and out of which a target of 171 numbers were allotted by government for providing benefits. The balance 73 numbers were not shown in the online website. Accordingly, a block level inquiry was conducted by Assistant Executive Engineer and Assistant Engineer of Hailakandi Division Development Block on 171 numbers of beneficiaries, and as per the report, 108 beneficiaries were found genuine.
So have you got the instruction?
I have got as far as the first writ is concerned, madam, not the second one.
Then you have to file affidavit. Otherwise, how do we decide cases? Let him file affidavit. How much time you want?
Madam, I have the instructions for the first is concerned. Second, since I don't have any time to obtain that one, but this one I can file, madam.
You take down heard Miss
A Begum.
A Begum, Learned Counsel appearing for the writ petitioners in both these cases. Also heard Mr. N.K. Devnath, Learned Standing Counsel PNID Assam, who submits that although he has received instructions in connection with item 30, yet instructions in item 31 are still awaited. Mr. Devnath therefore prays for 6 weeks time to obtain instruction and file affidavit covering the issues in both the writ petitions. Ms. M. Burman, Learned Government Advocate Assam, is present on behalf of the state. On the request of Mr. Devnath, these matters stand adjourned for 6 weeks so as to enable the Learned Department Council to file affidavit. Is there any interim order?
No lordship. 31 is same lordship.
Same order in both the cases. Common order, make it joint order.
Item 44.
May I please, Your Lordship. Lordship, in this matter, I am for the respondent number 1 and 3. Lordship, within this week, Lordship, I will file our affidavit.
last, on last rather than 3 weeks, they have sought for money. But the thing is that they are going with the workmen.
Now, what is this matter about?
Matter is about that one bio waste plant has been going to be, my lord, established, my lord. Against that, my lord, we are the complainant, my lord. Our complaint has been, in other way, it is rejected, my lord. So we have those on. There is a policy control is department, how they have given the permission to set up that establishment. That is the case, my lord. Now, this is the respondent board, he is the owner, he will set up the plant, my lord. Now, he is going with the construction, that is the thing. Now, in the inquiry report, it was one, the construction was stopped, but now I think that I have received instruction, they are going with the construction of the plant. That biomedical waste plant, my lord.
That is where is it?
Well, it is a Koharapathar in Borpata district, my lord. They are going to set a waste plant setup that is going to set up, my lord, that one. So we have filed an objection that it is a village area and so and so, so and so. Affidavit is required, my lord.
In this respect, I have received my instructions. From this instruction, I can make out that as per the environment impact assessment notification of 2015, all the parameters has been followed and they need to take prior environment clearance from the State Environment Impact Assessment Authority. That has been done. And public hearing has also been conducted with notices, and the results of the public hearing and all those notifications are in the public domain. So all procedural part has been followed while establishing this thing. So I need to put all my information in the way of an affidavit. So at least.
Yes, my lord. Short time, my lord. Already they have taken.
Very short time, only 8 weeks.
Yes, my lord.
8 weeks.
8.
16 and 19. What do you have to say? Anything you have to say? Achha. Heard Mr. B. Sinal and a counsel appearing for the writ petitioner. Writ petitioners. Mr. S. Burwal and his standing counsel, State Pollution Control Board, Assam, has appeared for respond numbers. For respond numbers
5.
Respond number 5 and submits that he has received instruction according to which all procedural formalities for establishing the what is this called?
Biomedical waste
common
treatment
biomedical waste
treatment plan
facility.
Common biomedical waste management facility. All procedural formalities have been complied with for establishing the common biomedical waste management facility, and therefore he be granted some time to place the relevant facts on record in the form of an affidavit. Similar is the prayer made by learned counsel for respond numbers 1, 2, and 3.
1 and 3, Lordship.
1 and 3. Miss MS D Das, learned counsel is present on behalf of respond numbers 2, 13, 14, and 15, and Miss B. Chetri on behalf of respond numbers 16 and 19, and also makes a similar prayer seeking time to file affidavit. In view of the above, let this writ petition be listed again after 6 weeks. So as to enable the-
Let it 3 weeks, my lord.
What will happen after 3 weeks?
Hearing,
If they comply with all provisions, we'll dismiss.
oh, man, that is they are saying compliant, my
If they
lord.
don't, then we'll break down the biomedical disposal, what else?
My lord, that
Construction of the waste disposal plan. If any, during the pendency of this writ petition will be subject to further order that will be passed in this proceeding.
all right.
Yes.
May I beg your lordship?
Hmm.
We have filed our affidavit in reply against the affidavit in opposition filed by the respondent number 2. Matter may be fixed for hearing. No?
You have received copies?
Not yet.
You have not
We
received.
will serve.
You will serve. You filed without serving. Miss so and so learned counsel for the, yes, your name please.
MSD Burma.
MSD Burman learned counsel for the petitioners submits that rejoinder affidavit in response to the affidavit in opposition filed by the respondent number 2 has already been filed on behalf of the petitioners, and therefore the matter be taken up for admission hearing after 4 weeks. Ms. M. Burman, learned government advocate Assam, however, submits that she is yet to receive a copy of the rejoinder affidavit. Be that as it may, on the request of Ms. G. Hazarika, learned SC Revenue Department Assam, and Ms. M. Burman, learned counsel appearing for respondent numbers 2 and 3, as well as Ms. S. Sharma, learned SC PWD Assam. This matter is directed to be listed again after 4 weeks by tagging the rejoinder affidavit with the record of this case.
May it please your lordship, my lord, if your lordship turns to page 149.
Yes.
My lord, this was the earlier order where this is a cooperative society, my lord. Our license has been suspended, thereafter it was cancelled. We approached this court, my lord. Court said that there is an appeal pending, go and get it disposed of. But after the appeal, now we have it before your lordship. The only reason, my lord, in the appeal, the finding is at page 167. Last paragraph.
May I interrupt for a moment, my lord? In this matter, affidavit is ready, my lord. It's sending for writing. May I have 2 weeks to file the
Affidavit on whose behalf?
my lord? On behalf of respondent number 3. It is yet to be filed.
Miss
My lord, here, the issue was for cancellation of my license.
Issue is affidavit, not cancellation. What do you have to say on that?
My lord.
Are you opposing her prayer?
No, my lord, that I.
Or I heard Mr. P. J. Rajchandran, learned counsel for the writ petitioners. Also heard Ms. M. Burman, learned government advocate Assam, who submits that counter affidavit on behalf of the respondent number 3 has already been prepared.
Yes.
And is being sent for waiting.
Waiting.
Therefore, 3 weeks time be
Right.
granted for placing the same on record. In view of the assurance given by the learned government advocate Assam, that within 3 weeks from today, the affidavit shall be brought on record by serving advance copy upon the petitioner's counsel. The prayer for adjournment stands allowed. The registry to list this matter again after 4 weeks as fixed item by tagging the rejoinder counter affidavit, if any, file on behalf of the official respondent.
Fixed.
May I please your lordship?
Yes.
Lordship, this matter pertains to non-payment of contractual bills. Or notice was issued. As per the lordship, they are supposed to file the affidavit. Today it has come up for this.
This matter pertains to non-payment of contractual dues. What do you have to say?
Lordship, this made actually seat corporation, this is instruction is required, Lordship. There's a
The learned
separate standing
Department
council.
Council prays for some more time to obtain instruction. Prayer allowed registry to verify whether this matter pertains to civil bench 4/5 and list the case before the appropriate bench again after 2 weeks. So as to enable the learned Department Council to obtain instruction. Yes.
Deeply obliged.
Item 41.
Lordship, in this case, I have received instruction by 3 weeks time may be granted to file affidavit.
Lordship, in the interim, the construction work in the unauthorized part may be stayed. They have constructed a building violating the permission of GMC. It was for G+3, they constructed G+6.
So while moving the matter, you didn't ask for an interim order.
That court did not consider this.
So today, how we can give it? You have to file a fresh application then.
Lordship, since they are taking time for
That's
inspection.
correct. So your interim prayer has been rejected.
Lordship.
So merely because the judge changes, it doesn't mean the court changes.
Lordship.
Either you have to wait or you have to file an appeal. or make a fresh application.
Lordship.
What do you want to do?
I will file a fresh application. Fresh application, additional application, Lordship, additional affidavit,
Correct, because that interim prayer is gone now.
Lordship.
I am paying for response of 4 and 5. No, I pay for 4 weeks time to file everything.
And how much time you want?
My lord, 4 weeks, after 4 weeks, my lord, I will receive instruction.
Acha, Mr. D. Borua, learned counsel is present on behalf of the petitioner. Ms. S. Chutia, learned counsel appearing for the respondent number 1, as well as Mr. S. Mukta, learned counsel representing the respondent number 2 and 3. Have 2 and 5.
4 and 5.
4 and 5.
Yes.
Have both wait for 4 weeks time to file affidavit. None has appeared for respondent numbers 2 and 3.
My lord, I am appearing, my lord. 1, 2, and 3, my lord.
Acha, then 1, 2, and 3. Yes, okay. Mr. Borua, on the other hand, submits that despite the pendency of this writ petition, the respondents are who are making the construction?
Respondent number 4.
The respondent number 4 is going ahead with the construction, and therefore an interim order restraining further construction is called for. First up, the said prayer was not granted by this court while issuing notice by order dated 19, while issuing notice of motion in this case by order dated 19/7/2023. Therefore, in the absence of a proper application justifying such an order at this stage, the prayer for interim relief cannot be considered. First up, on the request of learned counsel for the respondents, this matter stands adjourned for 4 weeks so as to enable them to file affidavit.
Marvelous.
Item 42.
In terms of your lordship's earlier order, we have taken dusty service. It is completed, my lord. The service is complete. They have to file affidavit. The matter has to be heard.
Affidavit is prepared, my lord, send it for vetting, my lord. So lordship, kindly quick
Actually,
send.
that's the service on whom?
Respondent number 5. We have filed affidavit.
You are appearing.
Respondent number 4, my lord, on behalf of 1, 2, and 4. Affidavit is prepared on behalf of respondent number 4, my lord.
Actually, anybody has appeared for respondent number 5?
Respondent number 5, my lord.
Yes.
All right. Heard Mr. B.D. Das, learned senior counsel, assisted by Mr.
HR Das.
H.R. Das, and counsel appearing for the writ petitioner. Also heard Miss
PR Mohanto.
um,
PR Mohanto.
P.R. Mohanto. Government advocate is no P.R. Mohanto, learned standing counsel, higher education department, Assam, appearing on behalf of the respondent numbers 1, 2, 3, and 4, who submits that instructions have been received.
Affidavit is prepared, send it for vetting, my lord.
And the affidavit has also been prepared on behalf of the department, but the same has been sent for vetting. As such, 4 weeks time be
My
granted
lord.
for bringing the same on record. Mr. Your name, please?
J. Borman, my lord.
Mr. J. Borman, learned counsel who has entered appearance on behalf of respondent number 5, also makes a similar prayer seeking time to file affidavit. And in view of the request made at the bar,
She was asking for 2 weeks.
2 weeks.
My lord, fix,
But
This can be
Vetting
sorted
them,
because the tender notice in.
we have fixed other matters after 2 weeks.
I leave it to you, Respondent. Let it be 3 weeks so that matter can be sorted.
We'll make it 3 weeks. In view of the above, the respondents are directed to file affidavit within 3 weeks from today. Register to list this case for admission hearing after 4 weeks, right? What is the issue about?
Well, in violation of the tender, the petitioner was supplying bus value to the institute. So now they have been issued a tender notice, my lord, saying that my lord, they are to apply bus, but subsequently, my lord, it is found that the private respondent has supplied the bus in violation of the NIT, which I could have also done it. My lord, he has taken the bus on hire and he has supplied.
All right. All right, then let them file their affidavit.
Yes.
Item 43.
We have received instruction, my lord. Accordingly, I may be allowed 3 weeks to file affidavit.
Mr. A.K. Datta, learned counsel is present for the petitioner. Ms. M. Borman, learned government advocate Assam, appearing for the respondent numbers. You have for respondent numbers?
My lord. 4, 5, my lord. 1,
4,
4 and 5.
1,
4 and 5.
1, 4 and 5 submits that she has received instruction and therefore 3 weeks time be granted for bringing the same on record in the form of an affidavit. Ms. S. Kemprai, learned SC KSC, and Ms. G. Hazarika, learned Standing Counsel Revenue Department Assam, are present on behalf of their respective clients. Full stop. In view of the request made by Ms. Bormont, this matter stands adjourned for 3 weeks so as to enable the learned departmental counsel to obtain instruction and file affidavit. Interim order passed earlier to continue until further orders.
Supplementary is for admission, item 54.
May I please your lordship? Lordship, in this matter, lordship, pleadings is complete, lordship. Lordship, my today, this matter is supposed to be written by my senior, but he is having some personal difficulty today, lordship. Otherwise, lordship, pleadings is complete, your lordship. Matter will be
What
taken
do you want today?
Lordship, at any other day, lordship, as per your lordship's convenience, lordship.
What is the matter about?
Lordship, the matter will, lordship, we are challenging the illegal act of demolishing our house without any notice from the deputy commissioner, neither any order from the deputy commissioner. We are thrown out from the concrete house, residential house, lordship, and they have filed their affidavit in opposition, but no such order was annexed to their. But we have filed our petition of reply.
House demolished without any order.
He was occupying a government land which was meant for road. So accordingly, that part was removed.
But without any order, without any
Government land,
hearing,
lordship.
lordship.
18 to under following 18 to. That is our affidavit, lordship.
We have filed our counter affidavit, lordship, without any order. They could not furnish any.
And
order.
they are mentioning about that
No,
number.
Mr. Sharma,
Lordship.
you have done the right thing. But you will have to pay compensation if you have suffered any loss for that.
Yes, lordship.
That you will have to pay.
Lordship,
could
I
be
will
in
argue on
crores.
that point on the next day, lordship.
That could be in crores because the mere fact that and these provisions, eviction from government land under land revenue
Lordship.
regulation in 1886. These provisions will have to see, court will examine
Yes,
how
yes.
relevant it is.
Yes, lordship.
Today's context, how can you throw out people just like
No. Yes, lordship. If any
Even if
illegality
it is
has been
enforcer.
committed, lordship, we must have to. We must have to.
We have
And if it is
categorically
a
placed.
vacant land, one can understand. Somebody is residing over the land by
Concrete
constructing
building.
house. That
Lordship.
is a different matter. We'll examine this.
Lordship.
Anyways, Mr.
H. Mojumdar, lordship.
Is Mojumdar and counsel for the petitioner submits that pleadings are complete in this case and therefore the matter be posted for admission for final disposal at the stage of admission hearing any day after 2 weeks. Mr. H. Sharma, learned additional senior government advocate Assam, and Ms. G. Hazarika, learned standing counsel revenue department Assam, are present on behalf of the state. On the request of the petitioner's counsel, registry is directed to list this matter for admission hearing as a fixed item, again after 2 weeks.
Obliged.
Mr. Sharma, please also instruct
on
your
the-
clients. Some judgments are there which should not be
Not-
misunderstood.
Yes.
If there is a agricultural land, somebody is occupying it is a one thing. But residential land is government land,
Lordship.
that's a different area.
Lordship, only notice upon the private respondent was not served, lordship. Notice upon the private respondent was not served from this honorable last occasion, lordship, because we have made
Actually,
categorical
admission
effort.
hearing, list after 2 weeks after verifying as to whether all the respondents are served in this case.
Obliged.
For orders, item 44, Partner.
May it please your lordship, as per last order, 5 lakh was deposited to the petitioner's account, your lordship, but without any interest, your lordship.
Without any,
Interest, your lordship.
you take down, Mr. S. A. Borbia, learned counsel for the writ petitioner submits that. Now, you write, Mr. A. S. A. Borbia, learned counsel is present on behalf of the writ petitioner. None has appeared for the respondent bed. This matter has been listed today in terms of order dated 10/08/2023, passed by this court. Full stop. Mr. Borbia submits that an amount of rupees 5 lakhs have been deposited in the bank account of the petitioner, but no interest amount has been paid to him. Be that as it may, from the submission of Mr. Borbuya, it is apparent that the directions issued by this court by order dated 14/6/2023 has been substantially complied with by the respondent bank. Full stop. If that be so, further hearing, in that be so, the matter can now be heard and disposed of finally on merit. As such, when do you want it?
On 9th of October, your lordship.
As such, and on the request of Mr. Borbuya, registered to list this case as per roster on 9th of October 2023.
Deeply obliged.
As per roster.
May I please your lordship? Lordship, matter
You
related
write
to
as per relevant roster.
May I please your lordship? Lordship, matter relating to contempt case lordship. In the Honorable High Court order dated 10/2/2022, WBC number 951/2019.
What is it, Mr.
My lord, there are the direction on the respondents to, my lord, pay some 4 lakhs and around 9 lakhs rupees to the petitioners, my lord, two petitioners for Zirat compensation, my lord. My lord, it is not that we are not complying, my lord. Actually, the fund will has to come from this respondent number 1. They are not a party here. The direction is on us. This is a scheme by the NHEI, my lord, and we have been writing, my lord. So, my lord, I have got some instructions today also, my lord. I want to bring all this in a form of affidavit. It is that, my lord, that fund has to come from the central government, my lord. And we are pressing very hard. We have been continuously writing to the NHA and this MORT so that they can disburse the fund, my lord. So I will bring everything on record, my lord, for an affidavit, my lord.
2 weeks time.
2 weeks time, my lord.
You are appearing for whom?
I am appearing for, my lord, here, the chief engineer.
No,
My
give me
lord,
the respondent number.
Respondent number 1 and 2, my lord. 1 and 2, my lord. PW.
All right, your name, please.
MS N. Kolita.
MS Enkarita, learned counsel is present for the petitioners. Mr. R. Dhar, learned counsel appearing for the respondent numbers 1 and 2 submits that his clients are ready and willing to, his clients are taking necessary steps for compliance of the court order. But since the order cannot be complied with unless the funds are received from the central government, which is not a party to the proceeding. Hence, he be granted 2 weeks time to place the relevant facts on record in the form of an affidavit. Prayer allowed, list the matter accordingly. Yes.
Okay, 47.
Lordship, is a contempt for non-compliance of order. There's 15/6, Lordship, 15/6/2022, Lordship. Direct
Notice has not been issued.
not issued.
So Mr. D. Dole, notice, etc., 8 weeks. How many contemnants?
4 contempts.
Yes.
Deeply.
48. And 49.
My lord, in this case, what had happened, my lord, in respect of a tea garden, in fact, 2 tea gardens, my lord, in Karbi Anglong district, a mutation order was passed by the Revenue Authority of the Karbi Anglong.
Why this matter has been listed for order
We
today?
have not yet filed the affidavit, my lord. My lord, sometimes is required, my lord, regarding
My
the
lord,
mutation of the land,
my
my lord.
lord.
Lordship has given me the last chance also, my lord, 3 weeks. They will file it, my lord. We have make it ready.
Kindly see the order sheet, how many times my learned friend has taken time. My lord, they are taking side with the respondent number 8, my lord. And he is a person from Nagaland. How in a 6th schedule area, my lord, a Nagaland can own a garden, my lord? Openly they are siding with the other side, my lord. Kindly see how many times he has taken time. My lord, notice was issued on 25.
My lord, what happened, my lord? I'm saying, my lord. that in the last occasion, my lord, in the mutation case, all the parties were asked to produce the original documents, my lord. Original documents, none of the
Just a
parties.
moment, just,
My lord.
what is the, Mr.
My
Chaudhary,
lord,
what
all
is
that
the?
we are praying is, my lord, earlier there was a mutation order in favor of respondent number 8. On an appeal filed by the original owner of the T state, my lord, that mutation order was cancelled. Thereafter, my lord, we filed a mutation case that it should be registered, mutated in our name. The matter was heard by the, my lord, authority on 17/6/22, 18/7/22, 22/8/22, and 29/22. Then, my lord, we approached this honorable court way back last year, my lord. And in spite of all these days, they are not passing the final order. The idea is, my lord, to facilitate the respondent number 8 so that he can get the compensation, my lord. A part of the garden land was also acquired for, expansion of the national highway. And there's an order of your lordships whereby, my lord, it was said during this dispute goes on, compensation should not be paid. In spite of that, my lord, out of 47 crore, 10 crore has already been paid. All that they are to do is to pass an order, my lord. They are not passing an order. Why should a mutation case take 2 years, my lord? What is their earthly reason? And my learned friend every time appears, he says, I want time, I want time.
No.
My humble submission is,
All right, but this is a
give them 4 weeks time,
Yeah.
so they will pass a final order in the mutation case. What is there to file affidavit, my lord?
For filing the final order in the mutation case, all the parties are required to be heard, my lord. There are 3 parties, my lord. The first, my lord, the original owner, they died. They transferred the land to another tea company. That tea company failed to pay the, my lord, dues to the bank, my lord, for mortgage. And that was auction. Then thereafter, my lord, one NGO purchased the land. All the notices were issued. All of them appeared. Last occasion, my lord, the Joint Secretary passed an order to produce the original records claiming the petitioner also took time on the last occasion, my lord, for filing the, my lord, original documents. It is not the left.
All right, all right.
So we'll file the affidavit, my lord. We'll bring it all the record.
No,
all
instead
the
of filing affidavit,
Exactly.
why don't you take 8 weeks' time and pass an order?
Yes.
My lordship may that grant us 2 months time, my lord. The pendency of this petition or the lordship may dispose of the petition that will 2 months will pass the order, my lord. 2 or 3 months, my lord.
Not 3 months. Not 3 months.
My lord, if the other parties, my lord, they could not file the original documents, they would file the order, my lord, like that way. If the petitioner also fails to furnish the original
My lord,
documents,
if
that regarding
somebody
the
is
inherited.
not
My lord,
furnishing required document, that
another-
can be taken note of an order can be
The
passed.
High Court passed an order in another case that the NGO who claimed that he purchased the land, they got an order from the Honorable Court that for their in that particular case. So we are handicapped, my lord. All these things are there. Without
So you pass the order saying that we are handicapped.
Yes.
No, we'll pass the order that, my lord, that they failed to produce the records, petitioner will fail to produce the records, we'll pass the order, my lord.
Pass an
Like
order.
that, my lord, within
There
3
were
months, my
orders.
lord.
See, if you can't say that because they are not giving you,
Yeah.
that is
Now
the order.
we are giving the opportunity to the petitioner, to the other
Yes.
private respondents
If the-
to produce the original.
Some party
documents.
cannot.
And
Produce the original, my lord, lordship may dispose of it like that way.
Lordship will also make an observation, my lord. Respondent number 8, who is represented, my lord. He is a person from, by his own showing in the other writ petition, kindly see how he has described himself. He is a person from Kohima. How a person from Kohima can buy property in tribal belt and block?
But these are things.
No, my lord, that
If
is
you
also.
want this to be decided, then the matter will have to be hard. Today, the order has to be without expressing.
Let them pass an final order
Yes.
within a time, 6 weeks from today, my lord.
Now, why 2 writ petitions?
The other petition, my lord, that private respondent, they filed a petition claiming that they are in possession of the land and that they are encroaching the land, so eviction is required to be carried out.
Now,
All right,
kindly see,
now,
my lord.
just a
So
minute.
High Court is a forum. Please have a look
Just-
at that writ petition, my lord.
Just a minute. The first writ petition, that is WPC number 357.
That we have
That is in
filed.
respect of
That
mutation.
is
we have
your
filed.
writ petition. So there the lady who is the wife of late Robin Brahma.
My lord.
Yes,
She had submitted an application for mutation of 2
yes.
tea
And we
states.
want disposal of that case.
Right.
Our
So
simple.
when was the application filed? Is it on record?
20, my lord. Yes. 1 second, my lord. There are 2 questions. (124) Niji. It was in 2020, my lord. page 124, my lord. Page 124 is the application, my lord.
But there is no date.
It is, my lord, 22/9/2022 in the left hand side, my lord, received on
22/9,
2022.
Filed on, yes, my learned friend is correct.
2022.
Yes.
22, my lord.
And the other petitioner, he had objected to grant of- You are representing him.
Lordship.
Who is the petitioner's counsel in the other writ petition?
I am the petitioner's counsel, your lordship. So far, pursuant to the honorable court's order dated lordship 27/2021, lordship, we filed a representation before the competent authority. Lordship, that representation so far that has not been disposed of by the state authority, and because of that, we have approached before this honorable.
What is your representation about?
That is about lordship, because the
Petitioner should also be heard
along with me.
me, my lord,
Because
regarding
my-
the position of the land.
Because my allegation.
You are claiming possession over the tea garden land.
My
My land has
encroachment.
been encroached by some armed miscreants, lordship. Because of that, I approached the competent authority on several occasions. That was not given hard. That was not hard lordship, and I was frustrated with them. Because of that, he approached before this honorable court, and honorable court passed the order. So far, I have pointed out, your lordship will find at page 23 of my writ petition. In the second writ petition, page 23, your lordship.
So some order was passed on 29/11/2016. What is that?
By this, in this case, my lord.
No, by the joint secretary, as per the synopsis in your writ petition.
Yes.
Earlier, it was, my lord, divided between the, my lord, two groups, my lord, petitioner and the respondent number 8, my lord. And that was again filed by the appeal was filed by the, my lord, original owner, my lord. Then it was, my lord, appeal was allowed, and the order was passed to hear all the parties, my lord. Earlier, it was two states were divided between the petitioner and the respondent number 8, my lord, earlier order in 2016. Then the appeal was filed by the original owner, my lord. Original owner of the tea state, my lord. Then it was, my lord, that order was without hearing the other sides, order was passed, so it was, my lord, cancelled.
All right, so without
My
going.
lord, one thing, my lord, please come to the other writ petition, my lord. Well, just one thing, my lord, please come to paragraph, page 17. Please have a look at their prayer, my lord.
No, Mr. Chaudhary.
I'm just
what-
pointing out, my lord.
Yes.
To issue a writ in the nature of mandamus or any other appropriate order or direction of like nature directing respondent authorities to restrain miscreants from trespassing into a 226 court, my lord, this is the prayer. This is their main writ petition. Miscreants, lordships will issue writ against miscreants.
That's all right. But only order I propose to pass is
Let them complete the proceeding, my lord, within a time frame.
they will dispose of your application.
Exactly.
That's all.
Yes.
What order they want to pass it. is
Yes,
open for them.
yes.
Take down. Heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. What is his name?
D.K. Bora.
D.K. Bora, Learned Counsel, appearing for the writ petitioner in item 48. Also heard Mr. Mr. D. Bora, Learned Counsel for the writ petitioner.
And respondent here also, my lord.
In item 49, who is also the respondent number 8 in WPC number 357 of 2023. First of Mr. J. Chutia, Learned Standing Counsel KAC.
On behalf of respondent number 2, 3, and 4.
Is present on behalf of respondent numbers 2, 3, and 4. Mr. H. Sharma, Learned Additional Senior Government Advocate Assam for for the respondent number 5. Mr. D. Ganguly, A. Ganguly
Private respondent.
for respondent number 10. Ms. G. Hazarika, Learned SC Revenue for respondent number 1. Just arrange it serially. And Mr. R.K. Talukdar, Learned Standing Counsel NHI DCL for item number 7 in item 48. Just arrange them together. Item number 49. Let's go number 4 for item 49. Full stop. the petitioner in WPC number 357 of 2023 is the wife of late Robin Brahma, who is aggrieved due to non-consideration of her application seeking mutation over 2 tea estates purchased by her deceased husband during his lifetime, namely Lahori Jan Tea Estate and Nirmal Kumar Tea Estate. Full stop. The original owner of the tea estate was Messrs. Of both the tea estates was Messrs. Hanuman Tea Company Limited, which is implicated as respondent number 9 in the present proceeding, in item number 48. Full stop. The respondent number 8 herein, who is also the writ petitioner in WPC number 661 of 2023, has had filed objection opposing the prayer for grant of mutation made by the writ petitioner in item 48, inter alia contending that a part of the land owned by him had been encroached by miscreants, and therefore, unless the encroachment over the land is freed by the authorities, granting mutation in favor of the applicant, namely Srimati Apu NTP, would prejudice his interest over the adjoining land belonging to the petitioner. First up, Mr. K.N. Chaudhary, learned senior counsel for the petitioner, has strenuously argued that despite the lapse of several months, no, it is despite the lapse of nearly 1 year since his client had submitted an application under Section 2 of the Assam Land and Revenue Regulation 1886, seeking mutation in respect of the aforesaid, seeking mutation of the name of the petitioner over the land in question. No order has been passed on the said application for today, till today, for no valid reason. First up, Mr. Chutia, learned standing counsel KSC, on the other hand, submits that the delay has been caused due to non-furnishing of relevant documents.
Original document. Original or certificate copy.
Original documents by the contesting parties, insofar as, inasmuch as even the writ petitioner in item 48 had sought time before the authorities to place the original documents. First up. According to Mr. Chutia, if some time is granted, the entire facts will be placed before this court in the form of an affidavit. Full stop. After hearing this,
One second, I'm sorry to interrupt, my lord. On 2 occasions, we were, present with the document. The presiding officer was not there. That instruction, my learned friend.
I have also instruction, my
Mr.
lord.
Chaudhary has,
At that time,
however,
my lord,
refuted such submission
but
of
the
the
son of the
learned.
petitioner died on the last
Yes,
occasion, my lord, on
yes.
that day. And the next date, my lord, his son was died, so he was not present, and the date was given, my lord. That was, and the
By
next date
contending
also, he
that
was present in the High
On a
Court.
few occasions, the presiding officer was absent, although the petitioner was present with the relevant documents. Be that as it may, after hearing the submissions made at the bar, this court finds that the basic grievance of the petitioner in item 48 is pertaining to the fact that her application seeking mutation over the tea estate land, as mentioned herein above, has not been acted upon by the authorities till today. Full stop. On the other hand, the respondent number 8 in item 48, that is the writ petitioner in item 49, has filed his objection opposing to the prayer of mutation on the grounds stated therein. Full stop. Be that as it may, since an aggrieved party has approached the concerned authorities seeking mutation over the plot of land which she claims to be the property of her deceased husband, whatever be the outcome of the prayer made in the application for mutation, the competent authority would be required to pass an order therein based on the documents placed before it by the contesting parties. Full stop. Even if one of the parties to the proceeding fails to produce certain documents, that by itself cannot be a ground to delay an order in an application, particularly when there is some urgency expressed in the matter by the applicant. Full stop. In view of the above, without expressing any opinion on the merit of the claims and counterclaims of the parties, and as agreed to by them, both these writ petitions are disposed of by granting 8 weeks time to the respondent number.
Joint Secretary, my lord.
Respondent number
Four.
4, my lord.
To the respondent number 4, that is the Joint Secretary,
Revenue.
Department of Revenue, Karbi Anglong
Department of Revenue, Karbi Anglong Autonomous Council, DFU, to pass appropriate order in the application submitted by the petitioner in item 48, seeking dated 22/9/2022, seeking mutation. Before passing such order, the objection filed by the respondent number 8
and
shall
10,
also
my
be-
lord. 10 also.
8 and 10
Ma'am.
shall also be taken note of. Full stop. It is made clear that it would be open for the concerned authority to pass appropriate order on the application seeking mutation based on the materials available on record on the date of passing the order. Full stop. Facilitating the above, the contesting parties are directed to cooperate with the authorities by producing all the relevant documents as has been called for. With the above observation, both these writ petitions stand
It
disposed.
will be, my lord.
8 weeks from today, my
My
lord.
lord.
8 weeks
10
from the date of submission of a
My
copy.
lord,
of
2
the-
months, my lord. It can be 2 months, my lord.
2 months of the basis.
What is the difference between 8 weeks and 2 months?
At least we will get 4 or 5 days more, my lord. It's 2 months, my lord. It can be, lord. 2 months.
1 week is 4 weeks.
My lord, 1 month, my lord. That
1 month is 4 weeks.
4 weeks, not sometimes, my lord, it is just 30 days or 2 days. 4 days, it is like that. 2 months, my lord.
Within 10 weeks.
10 weeks, my
from
lord.
today.
Yes, my lord. My lord. 10
Yes.
weeks.
Respondent C is deemed to be served. We have for 1 and 2.
1 and 2, madam.
So all respondents are served.
Lords.
Yes, heard Mr. S. Bothakul, learned counsel for the petitioner. Also heard Mr. Ardhar, learned counsel appearing for the respondent numbers 1 and 2. Perused Lohajima Court order dated 16/8/2023, which goes to show that presumption of service of notice upon respondent number 3 has been drawn. In view of the above, this matter is deemed to be ready as regards service. Register to list this case for admission
Date may be fixed.
after 3 weeks.
Problem.
Wait, you will all fix your own dates and then we will watch. We are creating a system when the lawyers will fix their date and we will just watch. Then we'll see how you fix your dates every case after 2 weeks.
Sorry, your lordship.
We are coming up with that system. Just wait for 1 or 2 months.
Lord. Online.
May I please the Lord? Refund of the matter relating to refund of the option.
We are seeking some time to file our affidavit because here we are applying for respondent number 2 and 3. So as per office note dated 29/3, the service is complete to respondent 2, 3 and 4. So I'm
You are appearing for whom?
only for respondent 2 and 3.
Lordship.
Wants to file affidavit.
Yes.
Mr. Gogoi,
Lordship.
any objection?
No objection, Lord.
Heard Mr. P.K. Gogoi, learned counsel appearing for the writ petitioner. Also heard Mr. Ardhar, learned counsel representing respondent number 1. Mr. A. Chetri, learned counsel appearing for the respondent numbers 2 and 3. Submits that he has received instruction and therefore be granted. How much time?
Any 3 weeks?
3
4
weeks time.
4 weeks.
Place the same on record in the form of an affidavit. Prayer allowed, register to list the matter again after 4 weeks. In the meantime, affidavit on behalf of the respondent numbers 2 and 3 be brought on record.
My name may be shown in the cause of time.
List this case by reflecting the name of Mr. Ardhar, learned counsel in the cause list.
Item 52.
In this case, your lordship, service has already been completed, your lordship.
Sorry?
Service completed, lordship.
Lordship, I have filed my affidavit also.
So let it be listed for admission then.
My lord.
Lordship.
It is submitted at the bar that this matter is Mr. You are Mr. Roy.
That's right.
S. Roy for the petitioner.
I am for 2 and 3.
I'm from 6, lordship.
MD Bora Fulani. Who is for respondent number 1? Any CGC present by Ms. B. Sharma? Learned CGC for respondent number 1. Ms. MD Bora Learned
Standing
Standing Council,
WMD department
WMD Department
for 2 and 3.
for respondent numbers 2 and 3. Ms. S. Sharma Learned Government Advocate Assam for respondent numbers 4 and 5. And there is no 6.
Lordship, I'm 6, lordship.
You are for 6.
Yes, lord.
Mr.
AK Das, lordship.
A.K. Das for respondent number 6. Who is for 7?
7 not
9
appeared.
is appeared for respondent number 7. However, office note dated. What is the office note?
Service completed, your lordship.
Where is the office note?
Lodgement order, lordship.
Can you tell me the date of the Lodgement order?
For your lordship.
However, Lodgement court order dated 16/8/2023 indicates that service of notice is complete on respondent number 7 as well. As such, this matter is deemed to be ready as regards service. This is the case for admission after 3 weeks. In the meantime, parties to exchange pleadings.
My
Lordship. Maybe 2 weeks, lordship. The matter relates to scholarship, lordship.
3 weeks is fine.
deeply obliged, madam.
Production of this item 1.
Made pleasure. My lord, may kindly come to page number 37, my lord. There was a PIL where an order was passed. Please come to page 47. Sorry, 37. Please come to para 9. This is the operative portion of the order. We find that deputy commissioners of Bongaigaon, Kamrup Metro, Morigaon, Honitpur and Tinsukia have been given the responsibility to do the needful under the policy adopted by the state of Assam. In such a circumstance, we hereby direct the deputy commissioners of aforementioned district to take necessary action as required by law against the encroachers and file their personal affidavits verifying the actions taken in regard to removing illegal encroachment from tribal belt area. So this honorable court, my lord, passed an order saying that respective deputy commissioners will take necessary action in accordance with law insofar as removing illegal encroachment from tribal belt and blocks are concerned. My lord, this order was challenged before the Honorable Supreme Court. And the order is at page 147. And the operative portion of the order of the apex court is at 148. Please come to the second subpara. This apprehension, in our opinion, is misplaced. For the tenor of the order which is impugned in this special leave petition is merely to direct Deputy Commissioner to proceed against the unauthorized occupants in accordance with law, which presupposes that the Deputy Commissioner must explain the claim of each occupant on each case-to-case basis, and after recording satisfaction in the light of the evidence produced, before him proceed to pass appropriate order as per law. We may add that if that order is adverse to the occupants, the Deputy Commissioner must give reasonable time to the occupants to take recourse to appropriate remedy as may be permissible in law. In other words, Deputy Commissioner shall decide the proceedings uninfluenced by any of the observation made by the High Court in the impugned order. So essentially, Honorable Apex Court said two things, my lord. Each individual case has to be determined on the facts of each case. And if the order is otherwise adverse to the occupant, then an opportunity would be given to take recourse to appropriate forum, my lord. Now, what had happened? Now, kindly come to the impugned notice, my lord. The impugned notice is at page 39 onwards. One such notice is at page 39. They're referring to the order in PIL. It is hereby informed through this notice to you that you are encroaching the below scheduled land under tribal belt.
This is the notice of 2013.
Yes.
You want to stay of this notice?
No, my lord. What I'm saying is,
Hmm.
let them proceed, but in as they directed by the Honorable Supreme Court. Hmm? No, my lord, it's a, sorry, typographical error, my lord. It is 23. The vernacular is the next page, my lord. Vernacular is at next page. 5/8/2023. It is hereby informed through this notice to you that you are encroaching the below scheduled land under tribal belt and block of Baska Revenue Cycle for your residence cultivation. Therefore, you are hereby directed to vacate the below scheduled enclosed land occupied by you within 15 days. Now, where is the determination? Where is the opportunity given to me as directed by the Supreme Court? So on the light of the order passed by the Honorable Apex Court the other day, coordinate bench of this Honorable Court, but that order, my lord, has not been uploaded. Last Friday, this order was passed, my lord. Maybe today evening it will be uploaded.
It must be Thursday then, not Friday.
Oh, sir. Thursday, sorry, yes, last Friday.
Hmm.
So, my lord, this order presupposes
This eviction drive is pursuant to the order passed by the division bench of
division
this court.
bench. They themselves proclaim, my lord, reference PIL numbers.
What do you have to say, Mr. Bopujani?
My lord, this PIL number 78 of 2012, as is my lord reflected in page 41 of the writ petition, my lord. From the note, my lord, this PIL, my lord, addresses the issue of my lord encroachment of my lord land.
Mr. Bopujani, come to the point. He is saying there is a Supreme Court judgment which says give them an opportunity to be heard. Do that and carry on. That's all.
In fact, my lord, on the last occasion when a similar matter, my lord, sprang up before this honorable court, my lord, was pleased to dispose of that writ application, my lord, by giving a liberty, my lord, to the petitioners that they will have to.
Which is the order passed by the other court? Any
My lord,
case
that
number?
is not uploaded, my lord.
No, you
Case
can
number.
check it just now.
Case number 4794.
My lord, it is-
4724 of 23.
It is WPC 4724 of 2023. That petitioners are my lord Fazal Haq and others. My lord, there this honorable court was pleased to pass an order, my lord, on 17/8/2023, thereby disposing of the writ petition, giving my lord liberty to the writ petitioners as well as to other persons whose name figured in a common eviction notice. Of course, here it is individual eviction notice. In that case, it was a common eviction notice pertaining to my lord almost 19%. Now, they were given the liberty to approach the deputy commissioner by filing individual representations by 31st of August of this month, latest by 4 p.m. And it will be taken on board by the deputy commissioner and the representations will be disposed of individually. And if any adverse order is passed, then the deputy commissioner will communicate, my lord, to the person concerned. And till that process is, my lord, not completed, their occupation over the land in question has been protected.
Yes, correct.
So similar order in this
Yes.
case also? All right. Which court had passed this
And
order?
plus, my lord, if they.
Court number 17, honorable
17.
Justice, my lord, D.
The
Borua.
Borua. My lord, in case of any adverse order, 1 month time was given to approach the
All
appropriate.
right,
body.
we take down heard Mr. K. N. Chaudhary, learned senior counsel assisted by Mr.
Yes, Nawaz.
S.
Nawaz.
Nawaz, learned counsel appearing for the writ petitioners. Also heard Mr. Who is for the revenue department?
My lord, I am appearing for
Mr. R. Barbujari, learned standing counsel, revenue department, Assam.
my lord, for
appearing for-
respondent number 1, 6, 7, and 8.
For the respondent numbers 1, 6,
7 and 8,
7, and 8.
my lord.
Who is for the respondent number 2?
2, my lord, government. My lord, plain pipes.
Also heard Mr. Please inform him, R. Dhar, learned counsel for the respondent number 2. Mr. S. Rabha, learned SC BTC for respondent numbers
3, 4, and 5.
3, 4, and 5. 3, 4, 5, and 8.
It is represented by.
Circle officer, Buxar Avenue Circle.
No, here I am accepting notice, my lord, because I am appearing in the PIL, that's why.
Okay, then R. Barbujari, 8 or later time.
The
11 petitioners have joined together in the writ petition, assailing the individual eviction notices served upon them, directing them to vacate the plot of land under their occupation on the ground that they are occupying land falling in the tribal belt. Full stop. Mr. K.N. Chaudhary, learned senior counsel, submits that a perusal of the eviction notices will go to show that the same has been issued in terms of direction issued by the division bench of this court. Wide order dated 09/12/2019, passed in connection with PIL number 78/2012, third bracket of Pradut Kumar Bora versus State of Assam and others, third bracket close, page 28 of operator, wherein a direction was issued to all the deputy commissioners to take appropriate action as may be permissible under the law against encroachers of land falling in the tribal belt. However, submits Mr. Chaudhary, the special leave petition being SLP number
2121 of 2020.
Page 147.
2121 of 2020, referred against the order dated 09/12/2019, was disposed of by the Honorable Supreme Court by order dated 03/02/2021. 2020, by providing certain protections to the persons stated to be in illegal encroachment of land falling under the tribal belt. According to Mr. Chaudhary, unless the procedure prescribed by the order dated 03/02/2020 is followed, any action on the part of the respondents in seeking to evict the petitioners would not only be illegal, but also in clear violation of the order passed by the Supreme Court. Hence, these writ petitions. Mr. Chaudhary has further submitted that taking note of the observations made by the taking note of the directions issued by the Supreme Court by order dated 03/02/2020, coordinate bench of this court has passed a similar order directing the concerned deputy commissioner to consider the representation submitted by the notices and communicate the decision, if any, taken against them before any further action is initiated. As such, a similar order be passed in the present case as well. Full stop. Mr. Borpujari, learned SC Revenue Department, has not denied or disputed the basic contention of the petitioners' counsel, but submits that the petitioners be directed to submit individual applications, which will be considered by the Deputy Commissioner of Buxa. Full stop. Mr. Rabha, learned Standing Council BTC, has also adopted a similar stand in the matter. Full stop. From a careful examination of the order dated 03/02/2020, I find that the Supreme Court had issued the following directions in SLA, in special leave to appeal, bracket C, bracket close, number 2121/2020. Quote page 148, double tick. Double tick to double tick, page 148, full stop. Since the proposed eviction drive is evidently initiated in terms of the order dated 09/12/2012, passed by the division bench in PIL number 78/2012. Hence, the observations and directions contained in the order dated 3/2/2020 of the Supreme Court of India would be applicable in the case of the petitioners as well. As such, with the consent of learned counsel for both the sides, this writ petition is being disposed of at the stage of motion hearing by granting time to the petitioners till 31st of August 2023 to submit individual representations before the respondent number. What is the deputy commissioner? Respondent number six. That is the deputy commissioner Baksa,
My lord.
ventilating their grievance in the matter. Full stop. If such individual representations are submitted within the time prescribed by this court, the same be considered on merit and disposed of by individual orders passed in the light of observations made by the Honorable Supreme Court of India in the order dated 3/2/2020. Full stop. Until such time the aforesaid exercise is carried out and completed, status quo as regards the possession of the petitioner or individual petitioners over the land in question shall be maintained.
My lord, the other coordinate bench order, my lord, observation has also been made that if the order is adverse, then 1 month's time should be given, my lord.
That is there in the order of the Supreme Court.
Yes.
That's all in the light of the order of Supreme Court. Yes.
May I praise your lordship? Lordship, item number 2, 3, and 4 are similar matters, lordship. And lordship, the text of the case are such that lordship, since the year 1980 to 83, lordship, we were a licensee of the railway land, lordship, at Kolkata station. Now subsequently, lordship, in 2014, on 6/6/2014, an eviction notice was issued. We preferred a representation, then we were evicted, lordship. Lordship, we preferred an appeal before the Honorable District Judge, that was dismissed, lordship. In the meantime, they issued a communication that we may shift to an alternate plot of land. Subsequently, lordship, after dismissal of the Sessions Court order, we approached this Honorable Court. If your lordship's order, by virtue of your lordship's order, that is at page 40, lordship. The relevant is page 44, lordship. It begins at page 40. Page 44, lordship.
Yes.
May I read, lordship, the second paragraph, lordship. I find from the records that there are communications issued by the authorities on 25/10/2015 requesting each of the petitioners to shift to the alternative site, which instruction they are willing to comply, but the respondents are no longer willing to give effect to the said offer at this stage. Lordship, in view of the same, lordship, your lordship had directed down below, lordship, that it is therefore provided that all the writ petitioners, the bottom paragraph, lordship, that all the writ petitioners would vacate the land under their respective possession within 3 days from today, subject to the condition that they are allowed to shift to the alternative site earlier allotted to them. It is, however, made clear that such shifting of the petitioners to the alternative site would be a purely temporary arrangement and shall not create any right or interest in their favor over the land. Now, lordship, in terms of the same, the earlier plot which was allotted to us, we constructed the shops and we shifted them. That was continuing, lordship. Subsequently, lordship, on 8th of August, the writ petitions preferred by us were dismissed. The order begins at page 46, lordship.
Page 60 to 19, lordship. Relevant portion.
Yes, sir.
Last.
Page
paragraph.
46, it begins.
62, paragraph 19.
Paragraph 19.
So which writ petition was disposed of?
Lordship, the
writ petition filed by
the petitioner's hearing, lordship, challenging the eviction order, lordship. The Honorable Court came to a conclusion that the 25/10/2015 communication does not create a right in our favor. Page 18, paragraph 18, page 62, the writ petitions were found to be devoid of merit, lordship, and accordingly they were dismissed.
Just 1 minute.
Lordship.
Yes.
Lordship. If I may kindly take first the relevant portion at page 60, Lordship, paragraph 16.
Paragraph?
Paragraph 16, Lordship, page 60.
Yes.
Lordship, may I read it? The only other aspect which has fallen for consideration is whether any new license arrangement has been created because of the letter dated 20th-10-2015 issued by the respondent number 3. By letter dated so and so, the petitioners were advised to arrange for shifting from their earlier licensed plots of land to new locations indicated therein by completing the shifting work within 10/11/2015. It has been contended by the respondent railway authorities that the respondent number 3 had no power, authority, and jurisdiction to issue the letter dated so and the respondent number 3 issued the same without the knowledge approval from the competent authority. Lordship, issuance of that letter has not been disputed. They have disputed that he did not have the jurisdiction to issue so. Lordship, be that as it may, our petitions were dismissed, Lordship. Now, Lordship,
So now what is the problem?
now the issue is, Lordship, on 18/8, we have made a statement to the effect. On 18/8, the authorities had approached us verbally, Lordship, and said that within 2 days you have to vacate or we will demolish the entire thing. Now, subsequently, after filing of this, we had filed it on 19, Lordship. On 19, if I may, Lordship, we could not bring it by way of an additional affidavit because it was not numbered. On 19, they have issued us this notice that within 21st, that is today by 4 PM, if we do not vacate, then we will be evicted from the same area. Lordship, within 2 days eviction, practically within 48 hours, Lordship, and we were continuing, we were not unauthorized. We are occupying by virtue of this honorable court's order. All we are praying in this petition is, Lordship, till 31st of December this year, we may be allowed to continue. And Lordship, as regards the construction which was made by us, we are claiming for a compensation against the expenses incurred by us there. To that extent, Lordship, nothing more than that.
Lordship, in this state petition, they had prayed in one hand compensation that they have to shift it to the shops, etc. And also they are praying to let them allow to stay there up to 31/12, Lordship. But that was perhaps not their prayer in the previous, Lordship. That is why, Lordship, 19, paragraph 19, page 62, that now any land has to be allotted only through public tender. And they were given opportunity to participate in the public tender, Lordship. So in that view, Lordship,
Fact was,
is as per the master circular, Lordship, of 2005. It's not, now we have to give it only by public tendering.
Lordship, the stand of the authorities.
This is
in
the last paragraph of the writ petition which were disposed on
Lordship,
8/8/23, Lordship.
Stand of the authorities in the earlier round of litigation was that this plot, this alternate plot which we were allowed to occupy, that is required for constructions of officers' guest house and a circulating area. This observation was made in view of the court finding that if subsequently any license is given, then
No time
Opportunity
frame was
may be.
given in the earlier writ petition,
I
Lordship.
understand, Lordship, but within a reasonable, within 48 hours, Lordship, a 75 years old man, 73 years old.
That may have, they have, perhaps they could sought for some time in the previous writ petition. That some time.
All right, but
Lordship.
have you preferred any appeal against this judgment of the learned single judge?
No,
Till
Lordship.
date, no.
Lordship, we are ready to comply with the judgment of the court, honorable court. So we have made a statement to the effect. Our only prayer is, Lordship, within
All right, heard
2 days-
Mr. Chakraborty, learned counsel appearing for the writ petitioner. Peruse the averments made in the petition. The petitioner has approached this court apprehending eviction from the land under his occupation on the ground that only yesterday, only on 19/8/2023, an eviction notice has been served upon the petitioner, giving time till 21/8/2023 till 4 PM to vacate the premises. Mr. Chakraborty submits that the by vacating the earlier plot of land under occupation of the petitioner, his client had shifted to the alternative site as per an order of this court. First, although the petitioner is not opposing the move on the part of the railway authorities to take possession of the vacant land, yet the petitioner's grievance is twofold. Firstly, that he be given compensation for the constructions made over the alternative site, and also time till 31/12/2023 to vacate the land. Full stop. Ms. B. Sharma, learned CGC, appearing for the respondents, on the other hand, has argued that as per the what is it, SOP under
Lordship, master circular.
Master
as per
circular.
the master circular currently in force, no allotment of land can be made by the railway authorities without floating a tender. Therefore, the petitioner does not have any right which can be enforced in the present writ petition. Be that as it may, after hearing the submissions advanced at the bar, this court is of the opinion that the petitioner must be allowed some time to, and that the respondents should be allowed some time to place their stand on record in the form of an affidavit. Likewise, the petitioner should also be given time to file additional affidavit, bringing the eviction notices on record, which were reportedly served, which were allegedly served during the pendency of this writ petition. As such, issue notice of motion returnable on 9 September 2023. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to Ms. Sharma, learned CGC. You are appearing as CGC or SCNF Railway?
CGC.
CGC. So as to enable her to obtain instruction and file affidavit within 10 days from today. The petitioner may file rejoinder within a week thereafter, if so advised. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that a status quo as regards the possession of the petitioner over the land in question be maintained till the returnable date. List this case again on 9/9/2023 as a fixed item. 8/9. 8/9. Same order in the other two matters,
Lordship.
list along with.
Lordship, my learned friend may communicate this to the authorities because 4 PM, Lordship, we can get a copy.
Ms. Sharma, learned CGC to communicate the order of this court to the concerned authority. Telephonically communicate the order of this court to the concerned authority.
Much obliged, Lordship.